conditional order. Execution has already filed and it's going on. So let them comply with it. Until then, the execution will go on. They're just derailing it. They're just.
In 4 weeks, let them not precipitate, my lord.
The extension of time
Yes, madam.
will not stand in the way of the execution going on.
Yes, my lord.
No, stay is granted on
My lord, it's a conditional
judgment
order.
and decree, my lord.
It's
Yes.
a conditional order.
It's a conditional order. You have not
We
chosen to comply.
request, my lord, 4 weeks if it is not precipitated. Within that, we will try. Otherwise, anyway, they filed their execution.
No, my lord. My lord, it's a conditional order. It would amount to modification of the order itself.
My lord, it can be extended, but not the way I request for 4 weeks. An application is filed, my lord, to that end.
Said that the execution shall not go on. On condition that because it's within 6 weeks. Now, when does the time expire? When
My lord,
did the time expire?
Interim order expired, my lord, about 10 days back. 30th of August, August. 30th, my lord, 30th August.
4 weeks from the date on which it expired.
My lord,
The extent
30th September, my lord, my apology. 30th September, that 6 weeks expired, my lord. July. My lord,
30th?
6 weeks time was granted, my lord, in
Yes, when
April.
does the 6 weeks expire?
6 weeks is expired, my lord.
When?
My lord, it expires on July 30th, my lord. I've filed an application post that, my lord.
4 weeks from that date. You're probably
If I may-
almost there.
Yes, my lord, if I may request, my
4
lord.
weeks from that date. 4 weeks from the date when it
An
expired.
application is filed now, my lords, on 6/8/24, my lord.
There cannot
seeking
be
extension.
lacuna.
Yes, ma'am.
It has
Yes,
to be
my lord.
from the date.
Yes, ma'am.
Yes. Heard the learned counsel appearing on either side. View of the evidence in the affidavit filed in support of the IA. The time granted for
right.
depositing rupees 30 lakhs is extended from the date on which it expired by 4 weeks.
Yes, great.
Much obliged.
14, FIA.
Yes,
Lord, the respondent herein, my lord, called in question the order of the, my lord, the transfer.
yes.
Lord, lordships may kindly go to my lord. Lord, it seems, my lord, she has taken charge of the office as per annexure A2.
Parties are executive engineers,
My please, madam, assistant executive,
executive engineers.
assistant executive, AWM.
Are you sure?
Sorry, my lord, sorry. Executive engineer, lordship is right.
Executive engineer. Yes,
Annexure A2, my lord, according to the respondents, she has taken charge on 10/7/2023 at annexure A2, my lord.
please tell us from where to where was the transfer?
Lord, so deputation, she is from the Public Works Department on a deputation to the KIDB. It's a board.
Yes,
That is, my lord, that is the order that your lordship will find. My lord, in my lord, in the page 25 of annexure A1, page 25,
yes.
at item number 5, your lordship. That is
Hmm.
the first order.
Hmm.
Subsequently, my lord, annexure A2, page 29. Srimati Sushma, item number 2, my lord. Item number 2. I have also filed, my lord, the translated copies. my lord. It is in Kannada. Filed, my lord.
Yes, annexure A1 is on 3/7/2023.
Please, my lord. 3/7/2023. Subsequently, my lord,
Just a moment.
her name
The
is,
S is posted at zonal office Mysore.
please, at my lord, item number 5 in the annexure A1 is the
Hmm.
order with refer to the, my lord, respondent number 1.
Hmm.
Then, my lord, the next order after deputation
Hmm.
is annexure A2, page 29. Item number 2, my lord.
Yes.
Afterwards, my lord, she has taken charge on 10/7/2023, that is CTC, page 30. Then, my lord, annexure A4, page 32. Page 32, my lord, item number 4. Annexure A4, item number 4.
Yes.
My lord, that's a respondent, but repatriated to, my lord, the Public Works Department. 31/7/2024.
Yes.
This order, my lord, called in question by the respondents. Before-
A4 was challenged,
So please,
not annexure A1.
yeah, not annexure A1.
Yes.
Repatriation was called in question.
Yes.
Then your lordships may kindly, my lord, this is the order passed by the K8 that your lordship will find at page 74. Page 74, last annexure, my lord.
Yes.
This is your, may I read your lordship?
Mm.
Peruse the records. It reveals that the applicant belonged to Public Works Department, but he was deputed to the KEB as a range office in Metagalli, ARS Road, Mysore. Order dated 3/7/2023 at annexure A1. Thereafter, the second respondent has issued a reposting order on 10/7/7 at annexure A2. Accordingly, the applicant has taken charge on 10/7/2023 at annexure A3. Such being the fact, the fourth respondent has been posted in the place of the applicant, while impugned order 31/7/22 at annexure A4. In the meantime, at the time of hearing, the learned counsel for the Cavator R4 has filed a memo along with annexure R4 1 to R4 6 in open court. The same is taken on record. However, on perusal of annexure R4, a copy of the judgment of the Honorable High Court in so and so writ petition, it reveals that the applicant being aggrieved by the suspension order preferred a writ petition before the Honorable High Court of Karnataka. While allowing the said application, direction was given to the respondent authority to revoke the suspension order and to provide a suitable posting to the applicant. That is myself, my lord. Further, it reveals that as per the
Just a
decision of
moment. Provide a posting to the applicant means?
applicant to provided posting to me, my lord. I am the respondent for before the KIT.
Okay, yes.
Yes.
Mm.
Further, it reveals that as per the decision of the Honorable High Court of Karnataka so and so, in writ petition number so and so, it is the responsibility of the authorities to provide a posting to the applicant and the private respondent. Further, on perusal of the submission made by the learned counsel for the applicant, it reveals that the present post is an executive post. As per transfer guidelines so and so, a person facing department inquiry should not be given posting to the executive post, and there should be given non-executive post. Considering the above facts and circumstances held that the applicant has made out a prima facie case to grant interim stay of so and so. Order, operation of the order so and so, the impugned order was stayed.
Hmm.
Issue notice.
So
the
far as the applicant and the fourth respondent is concerned, we stay till next day. Issue notice to the respondents. In addition to that, the learned standing counsel is directed to accept. Yes,
Please, the lordship may kindly go to my submission before the tribunal at page 53, your lordship. Page
not
53
a
of the,
purely ad interim order. Should it not be considered by the tribunal in the first?
and my
Yes.
humble submission.
Hmm.
Lordship, I have produced, just I will not, my lord.
Yes, yes.
The memo where I produced document page 53, annexure B, my lord. Page 53,
Annexure?
annexure B
Hmm.
in the writ petition.
Hmm.
Your lordship, I kindly, my lord, the annexure R41 produced by me.
Hmm.
Lord, this is the order My lord, a suspension was, my lord, order was came to be passed against my client, that is the petitioner before your lordship. And annexure R42 is the revocation by the government.
R4-1 is a suspension order dated.
Dated, my lord, that is on 11/7/2023.
Hmm.
The revocation is on 16/4/2024.
16-4.
2024, 16/4/2024.
Hmm.
That is annexure R42, my lord.
Hmm.
Then,
Hmm.
my lord, they have produced I requested, my lord, the board and the government
Hmm.
to give a posting in view of, my lord, the revocation of suspension order.
Hmm.
Because the writ petition was pending consideration before this honorable court, before the learned single judge, questioning the suspension. And this court, my lord, the learned single judge, your lordship will find at page 65, annexure R44.
Set aside the suspension.
Please, my lord.
Was the suspension set aside?
No, my lord. This is the order passed, my lord. This is the order.
Hmm.
Because the government has revoked suspension. That's the reason this court has given a direction.
Hmm.
At page, my lord, writ petition disposed of, at page 67
Hmm.
of, my lord, the internal page 3 of the order.
Hmm.
Order, reserving liberty to the petitioner to pursue his representation dated 17/4/2024. The captioned petition stand disposed of. The respondent shall take cognizance of the revocation of suspension and pass appropriate orders on the representation submitted on 17/4/2024. The exercise shall be completed within a period of 4 weeks from the date of receipt of certificate copy of order. This order is not, my lord, implemented immediately, and I have filed, my lord, a contempt petition. There they have produced the impugned order.
This is on 22/4/24.
Please, ma'am.
The order was passed on 31/7/24.
Please, ma'am. And accordingly, my lord,
Hmm.
your lordship kindly go, my lord, this is the relevant
Hmm.
document, your lordship's page 69.
Hmm.
After, my lord, after this order, the impugned order before the tribunal was called in question. And my client has taken a charge of the office of the assistant executive engineer on 5/4/2024. That is, my lord, page 69, annexure R46. This is CTC, my lord. 5858.
5/8.
The transfer is, my lord, 31/7/2024.
Hmm.
And my client taken a charge of the office on 5/8/2024.
Hmm.
The KAT has passed an order on, my lord, 6/8. That is on next day. I made a submission that, my lord, I have taken charge. My lord, I will just another document regarding contempt is concerned.
Hmm.
My lord, that page. Page
73.
page 71, page 7.
Hmm.
The order, my lord, the direction issued by the learned single judge, my lord, to give a posting to the, my lord, the applicant, who is a respondent before the, my lord, tribunal, was not implemented. But I filed a contempt petition in view of, my lord, posting given to my client. My lord, that is the impugned order. My lord, this contempt petition has become, my lord, infractious. My humble submission, your lord, my lord. The petitioner, my lord, is, my lord, an employee of the KADB. Lordship, kindly, my lord, consider. He is an employee of the KADB. He is not a deputationist.
Yes.
He was suspended. The suspension was revoked by the government.
Yes.
And this court has given a direction to give a posting.
Yes.
Accordingly, my lord, posting was given in the place of the respondent.
Yes.
And whereas the respondent is, my lord, from the Public Works Department. She is a deputationist. The lordship is well aware, my lord, the concept of deputation. My lord, she was worked there And my lord, there are many number of employees from Public Works Department working in the KADP. KADP on
Method of
deputation.
appoint- What is the method of appointment of executive engineer in the KIADB?
Please, my lord.
What is the method of appointment of executive engineer?
Method of appointment, that is C and R, your lordship. my lord.
In the-
C-
In
C&R
the,
is there.
in the board,
Please, my lord. Board C and R is there, separate C and R is there. my lord.
yes, what does it
Okay.
say? How is it, what is the method of appointment?
May I pass on, your lordship?
Yes,
my lord?
please.
It is C and R.
Please. Is the post executive engineer civil?
Civil, civil.
Therefore, the method of appointment is 70% from cadre of assistant executive engineer, civil grade 1, 20% from the post, from the cadre of assistant executive engineer, civil grade 2, and
Great.
10% by
10%
deputation.
is for
10% is there for deputation.
10% is there.
Hmm.
There is no dispute about it.
Hmm.
But here, my lord, the majority of the employees are from the Public Works Department.
Hmm.
My humble request is that, my lord, the respondent is from the Public Works Department. The concept of deputation, your lordship is well aware, my lord, the Kunal Nanda case is there. My lord, may I pass on, your lordship? Just I will read, my lord.
If it is a deputation in terms of the cadre and recruitment rules, is there not a difference? Unless you can point out that the deputation is in excess of the 10%.
Please, my lord, that is an excess, my lord. There are nearly more than 50% is there, my lord.
Those are matters
But,
which now have
but
to
the,
be
my lord, your
considered.
lordship, I kindly see, my lord, just I will take your lordship. my lord. So I will read only 2 sentences out of, my lord, the
Yes.
judgment of,
Yes,
my lord, Kunal Nanda case. Your lordship has come across, my lord, sir, case. My lord, page 365,
yes,
my lord, the second line.
yes.
The basic principle underlying the deputation itself is that the person concerned can always and at any time be repatriated to his parent department to serve in his substantive position therein at the instance of either of the department, and there is no vested right in such person to continue for a long or deputation or get observed in the department to which he had gone
Absolutely.
on deputation.
There's no question of absorption.
Please,
Yes. the
but
question
here-
is only this.
but I am not from outside the, my lord, the KADP. I am employee working in the department, and this honorable court, learned single judge, issued a direction to give a posting, my lord, as per SEMA case, to give a posting. They have not immediately as acceded. Then, my lord, I have filed a contempt. Now an impugned order was passed before the tribunal to give a posting to me in the, my lord, at Mysore. That called in question by the respondent.
The question, senior counsel, is simply this. Are these not matters, the posting, the fact that it is on the basis of a contempt of court, it is on the basis of a direction issued by the learned single judge, and that the contempt was closed recording that you've been posted. Are these not matters that you must initially bring to the notice of the tribunal, and which has to be considered on the merits of the matter?
But the reason
For
is,
this court to, would it not be a short circuit of the entire?
my humble request, my lord, instead of granting, my lord, because I have taken charge on 5th, the interim order passed on 6th, my lord, I have brought to the notice of the KAT. My
The
humble
fact
request is
that-
to maintain status quo, my lord. That's the,
Fact that you had taken charge on fifth
Please, my lord, on fifth.
had been brought to the notice of the,
Please, my lord, along with my
Tribunal.
lord, a memo. I have produced the document also, even CTC also have produced. And I have placed it before the KAT that I have taken charge on fifth. I am,
specifically why the KAT does not order, the KAT apparently feels that the prima facie, that there is a requirement for an order of stay, which is why an order of stay has been granted. Now, all these contentions, is it not for you to raise before the fact that you had taken charge by itself will not denude the KAT of its power to grant a stay in appropriate circumstances? Your contention is that in this case, where it was on the basis of the directions of this court that the order of posting has been granted to you, and where the contempt has been closed, the fact that the contempt has been closed has not been brought to the notice of the tribunal.
I have informed along with the memo I have filed, your lordship. I have stated.
No, Annexure C,
But
Annexure R4, 6,
Your
is-
lordship, I kindly, my lord, go to page 53. Page 53.
yes.
My lord, the relevant portion is at para 4, next page.
Yes,
It is submitted as per the order of the Honorable. The respondent number 4 has submitted a representation to the government, second respondent, and in spite of non-consideration of the respondent number 4, has filed a contempt petition number so and so. So I brought to the notice of my lord,
that you filed the contempt petition, you've brought to the notice.
please, my
But you've also brought to the notice that you
That is-
assume charge on 5A.
direction given by the,
But that the contempt has been closed, recording that you had assumed charge on 5A is not, apparently not brought to the notice. When is the matter listed there?
that is on before KT, your lordship. That is on my lord, 6/8/2024.
Sixth.
6/9.
It was already over.
9.
6/9.
6/9.
6/9.
Last. Impugned order.
Page
It is
impugned
in
order,
impugned.
lordship is KT order, your lordship. That is at page
9/8.
74,
8, your lordship. It's
6/8.
at page 77.
6/8.
29/9.
29/8.
Please,
We are almost there.
we're almost there.
Shall we direct this also to be considered there by the tribunal?
Please,
Because it is only an interim order.
my humble
I
request,
understand.
in view of my lord taking charge on fifth,
In view of taking charge on fifth is
Fifth, that-
according to
that
us.
is one
that is not-
aspect of the matter.
Yes, the
Lordship
more
is well
important
aware.
aspect of the matter is that the contempt has been closed,
What is
taking
the,
note of your
but
taking.
whether the applicant before my lord, tribunal has got a vested right, whether they have got a right to question your lordship, whether it's a repatriation, is a deputationist.
That
They cannot
exactly is
expand
the
the scope
matter,
of-
that exactly is the matter which the tribunal is considering. And for that purpose, it is listed on 29/8. We'll say that this aspect will be
I
considered. on
requested the
29.
tribunal matter to maintain status quo till the next date of already hearing.
That appears to be a conscious order.
Might I
At the
take-
stage of an interim order passed by the tribunal, whether this court should interfere or not is the question. If we start interfering at stages of interim orders, there will be
My lord,
complete
What is the
chaos
right,
in the functioning.
the lordship's kind? What was the right of my lord, the deputationist? As
Exactly,
held by my honorable Supreme Court. and in
exactly
several
the
cases.
question that we will direct the tribunal to consider on the next date of hearing.
Just one mention. This lady has been brought in the post and been there for less than a year, whereas under the rules, minimum 2 years, there can be no transfer.
Is that applicable to a
Applicable to us
repatriation?
also.
Is
please.
that
please,
applicable to
please.
a repatriation from a
It is,
deputation?
it is. Secondly, your lordship, what has happened is that
No, just a moment, to
Please.
say that it is. Do you have anything,
No,
Yes.
there is no such order.
Order, repair rules.
There is no consultation
what
in your
would you,
lordship.
what would you rely on to say?
Please.
That for a deputationist who is working in another establishment, you cannot be disturbed for 2 years? Because the transfer guidelines are not with regard to deputation.
Your lordship, as per the CNR rules itself, wherein the rules would apply for even those 10% who come under these rules. The same rules would be applicable to them too.
But then when it is a deputation,
Please,
it is for the borrowing authority to say whether the deputation is required or not. Now, here is a person who's been directed to be given a posting.
Your lordship, the order is very simple. His order that the High Court had passed was only in view of the fact that the Lokayukta had not sent a report on time, and therefore the suspension was revoked. And since his suspension at that point of time didn't stand, all it was said was find him a posting. Now the courts are very clear that you cannot put the person back at that very same post where corruption charges were held as against him, because that would send a very wrong signal everywhere. And specifically, your lordship, anybody who's under suspension and pending inquiry, suspension might have been revoked, but inquiry is still pending. Such being the case, for
Question
him to
again
go
is
back to that
this.
place.
Question again is this, when a person is being repatriated from suspension, does the person who is holding the post to which he is repatriated
Please.
have a right to say
Please.
that he shall not be repatriated in my place?
Yes, your lordship may kindly see Annexure A6, which is the government order, where it specifically says that key posts cannot be given to such persons. Therefore, that's also going against the rules. Now our difficulty is this, your lordship. There is an interim order by the tribunal protecting me because they have realized that on several aspects that they have not followed procedure. Despite that, even as of today, your lordship, he says, I will not follow the KAT order. He squats in the same chair. I'm left to sit outside, which has even been reported by all the newspapers. The lady is not even under repatriation. The rules are that she should be given another posting elsewhere. She has no posting, your lordship. She's made to sit outside, and this man says, I don't care. I will say that in view of the fact that I come from a particular caste, you're degrading me.
Just a
I will
moment,
continue
just
to
a
sit at
moment.
the same post.
Is it, as a matter of fact, you are seeking to argue the matter here rather than before
No,
the?
I agree with your
tribunal.
lordship that it could go there, your lordship. I'm only trying to bring to your
That is
lordship's
so.
attention.
If that is so,
Please,
the merits of the matter cannot be heard at your instance either. We'll
not
have
at
to-
all, not
We'll
at
have
all.
to send it back to the tribunal for a consideration.
All
on the
I am
merits.
seeking is, your lordship, just clarity that in view of the interim order, that would have to be followed, your lordship. Since otherwise I shall urge that on 29 there itself. Please.
Yes, my lord. So far as my lord, the interim order is concerned, my humble request is, my lord, is taking charge, is working there to maintain status quo. That is only my humble submission.
Will have to be considered by the tribunal, according to us. The aspect of the matter has to be considered by. What do you say? What about
As your
court?
lordship pointed
have-
out, whether this is a question of whether the deputation is under the general recruitment rules or because it is specifically under the CNR, what is the
My lord,
concept
there is
of
no
that
specific
will be
period is
reviewed?
also fixed, my lord, for a deputation. And there is no consultation from lint authority as well as the borrowing authority. Everything is silent.
Whether
There are-
all that is an open question. If it is within the 10% of the,
Then it's,
then it would be a different perspective altogether is what I prima facie feel. Let it be considered by the tribunal. We'll say that on the next date of posting, as far as possible, it will be. And please don't seek any adjournments on the next date of posting. We'll record that.
Please.
Heard both sides. What is under challenge before this court in this writ petition is an interim order passed by the tribunal staying the operation of the order impugned before it. The learned counsel for the petitioner submits that the petitioner had already assumed charge of the post pursuant to the order impugned before the tribunal on 5/8/2024. And that the orders of posting had been issued on the basis of directions issued by this court in annexure R44 produced before the tribunal. It is further contended that noticing the fact that the petitioner had assumed charge of the post on 5/8/2024, a contempt of court case filed by the petitioner came to be closed by a co-equal bench of this court on the same day. Full stop. The learned counsel for the petitioner further submits that the respondent here, a private respondent here, who was the applicant before the tribunal, was only a deputationist from the Public Works Department and would have no right to insist that she should be retained in the post in preference to a regular holder of the post. However, we notice that 10% of the post of executive engineer in the KIADB is to be filled up by deputation from the Public Works Department in terms of the C&R rules and C&R rules, full stop. Having considered the contentions advanced on either side, we are of the opinion that the consideration of the contentions raised by the parties in this writ petition would be a premature exercise, since the tribunal has posted the matter to 29/8/2024 for further arguments in the application. We are of the opinion that all the aspects of the matter, including Annexure C, are to be considered by the tribunal in accordance with law. The parties submit that there'll be no prolonging of the proceedings before the tribunal, and that arguments can be advanced before the tribunal at the earliest. The above view of the matter.
I could
we are of
request
the
one
opinion.
other line, that even with respect to our submission of violation of the interim order might also be considered by the honorable court.
That cannot.
That's. Your
That is
Lordship,
not the subject
that
matter
can-
of this.
I
Going
understand,
into
Your
the, my
Lordship.
lord,
Then they
All
get away
aspects of the
with.
matter are left open to be
Like a
discussed by the tribunal. The writ petition is closed with the above observations.
because my lord, in view of the interim order, I am without posting. Now the same case will come into my lord operation. I am without posting.
Yes,
Hearing on IS, number 15, Karnataka.
Appear for the respondents in both the writ appeals.
There are two appeals, one by the corporation, one by the employee. I mean, not that the respondents before the learned single judge.
what are the interlocutory applications which are listed today?
That's so,
One is for posting.
yes,
There is non-compliance of office objections in the second one. That is writ appeal 3473.
before seeing.
Yes.
Before.
You are for the employee.
I am for,
You are the employer. Well,
The matter pertains to.
Respondent, not the matter to be disposed of. I think the reason is only this, I just submit. The order in question is the petition, the petitioner or the director. They challenged without a seniority issued at actual jail. And in corporation, it's the promotion, the seniority is on quota basis.
yes.
Block by senior. And they contended that there was a break in blocks. Therefore, they should be given promotion over and above the, they should be shown place, the director recruiting over and above the promotion. That is the question. Then, the learned single judge passed an order, washing. I find the corporation, find the second recovery. And the order of the learned single judge. And promotion, if it was subject matter. So no promotion took place, the corporation wanted their final order, no promotion took place. Position as it is in 2030. But in the meantime, what happened was, or 50, the corporation was one case because that was bifurcated into 4 corporations, there was series of litigation, they don't want to bother with the Then based on which, I permanently allowed the officers of the single corporation to distribute the other 3 corporations. This took place by a government order dated 15/12/2020. The petitioners here, that is the petition, as also the respondents, who are the promoters, were called upon to exercise their option. They have exercised their option, and they've all been allotted respective corporations. I've stated, in the memo. Now, my lord, the seniority list is now the post which they are claiming, that is the assistant statistical officer post, which is the subject matter in the petition. Is corporation by seniority, is corporation by. It is not state-wise. So therefore, my lord, whatever their seniority is being finalized, the respective corporations. Because So the original trade-off for which they came. to
That
us
is
was
no
not
longer
done.
relevant.
Because the seniority is itself gets resolved in view of the, so I have stated so far.
So
And I
leaving open the contentions of the parties, the appeals can be closed. And the seniority in the respective corporations will be
Yes,
on,
it's already finalized and I'm informed, my lord, it's already finalized. Their seniority, my lord, in the respective.
if you have any objections with regard to the finalization of the seniority in the respective
My lord,
corporations.
may I
that can
just
be
make one?
Left
My
open.
lord, let her file a memo and serve a copy on me. We would, my lord, I'll just,
Because it's already ready. my lord.
Not at 2:30.
Because I.
We'll have it tomorrow.
very well, my lord.
They belong to, I thought so, I left it open. So.
We'll have it tomorrow.
Very well.
Please serve copies. If that is so, it can be closed.
Please.
Yes, please tomorrow.
16. Rajendra Kumar Sundhi.
For complaint, my lord, in this case. Lord, this appeal is against the order of the learned single judge, wherein a post, my lord, it's a backlog appointments, my lord, for the different faculties, my lord, the assistant professors and all in the university.
Yes,
In that, my lord, the scheduled tribe category, my lord, the post, there are two posts were notified. One is for woman, another is for open. Then, my lord, applications have been received by the university. And one person, my lord, was selected under open, a person has been selected and raised in open category. Insofar as woman category is concerned, my lord, no eligible applicants university could receive.
Hmm.
No appointments could be done, my lord, for that woman.
What is the post concern?
My lord, post is assistant professor, my lord,
In,
in the department of
Hmm.
architecture.
Hmm.
It's an engineering college, my lord.
Hmm.
It was earlier it was a constituent college of Bangalore University.
Hmm.
Now, my lord, during the pendency, it has become an autonomous university by itself.
Hmm.
And that's why, my lord, I have made an application to implement them because if at all, if this order has to be implemented, passed by the learned single judge, the autonomous university has to, because the post is there. In fact, notice has been served to the council has also been represented
Hmm.
because that university was not there, my lord, when the order was passed.
Just a moment. This is the university.
This is
Vishweshwaraya-
Bangalore University, yes, Vishweshwaraya College of Engineering.
Impleading has already been allowed,
Allowed,
It has been allowed, my lord.
has been allowed.
yes, my lord, it has been allowed.
Yes.
And the council also, my lord, has been, I think they have filed an.
Now, what is your application which is being heard today?
My lord, there is one more
Allowed.
application for impleading only.
Impleading is listed, but impleading has already been.
It has
allowed.
already been allowed and has been brought on record as fifth respondent. My lord, since 2022, my lord, I am not able to enjoy the fruits of the order passed by the honorable court. There is a direction to implement the order within 3 months. And I have also filed a contempt petition. And one pretext other than that, this university has been dragging on the proceeding.
University matters are before us. University matters are before us. Everything. Okay. So we'll list it for hearing. When do you want it?
Anytime, my lord, next week.
What was the direction by the?
For
learned single
admission, my
judge?
lord,
Just,
to consider the application of the petitioner, you be appointed as assistant registrar,
just a moment, just.
assistant professor, my lord,
Appointment order.
within 3 months.
Said was to be completed within 3 months from date of receipt of copy of this order. This is on 20th of July, 2022.
Yes.
Is there any?
There is a
interim
government order, my lord. In the
Yes.
event the women candidate is not available,
Hmm.
then of the same category of the male candidate can be filled up.
Hmm.
I was held to be eligible,
Hmm.
but since the post was reserved for women,
Hmm.
women candidate was not available. There is a government order to that effect.
Hmm.
In the event of non-availability,
Hmm.
it can be filled up of the same category.
Hmm.
Therefore, the Lawrence Sinker General has allowed the writ petition,
Hmm.
considering the government order,
Just
which
a
is
moment.
applicable to the university also.
Is there any interim order in the?
There is
No,
no
my lord,
interim order.
there is a
There is
contempt
no
was
interim
filed.
order. There is a
Contempt was
contempt
filed, my
petition
lord.
pending
Both of-
consideration.
Both were, it was supposed to be heard and disposed of the matter, my lord.
Hmm.
So that's why, my lord, there is
Are
no
you
interim
ready
order.
today?
My lord,
Are you ready today
today I am ready, my lord.
for a hearing?
Yes.
Yes, I am ready, madam.
Paso,
Good. Tomorrow, my lord, because I have 2:30, I have.
Short date maybe.
Hot on matter,
Any,
my lord.
any other, because I recently filed the wakalat.
A
Recently.
date may kindly be given, my lord. Date may kindly be given, so that
it's not today, we don't think we'll have a date in the
Tomorrow or day after?
going week. No, tomorrow, day after. Too many dates have been.
Next week, some?
Yes.
Next week.
Next week something.
In the same list, madam, let it be in the same list.
Yes.
Can be, with an understanding, it can be disposed of.
Yes.
28th.
Much of.
17. Gulati.
2 days.
It's a commercial appeal, my lord. 18 lakhs is recovery and amount.
Filing delay of 2 days.
Please, my lord. Delay in 2 days filing the applications. Due to some,
Notice has not gone.
no, my lord,
Notice.
please.
This emergent notice list immediately after service complete.
18. Hanumat Rajuyam.
The respondent
It-
haven't filed my objections to these applications.
Learned Council for the respondent seeks time to place objections on record to the application. This after 2 weeks.
19. A. Gunashekharan.
Years of rent.
The compensation that was due is yet to be dispersed. I'm
But
unable
there's
to
no
disclose.
compensation, nothing
I'm
is
unable
received.
to
madam.
disclose the reason
Every
why it is
hearing
not
date,
given
this
to
is an
me.
excuse that is given.
So
by-
there is 1 crore which is due.
So as a matter of fact, has
In
the,
fact, this court suggested that matter can be heard on merit and disposed of. I'm willing to do that, my lord.
has the rent been deposited?
No,
Rent
my
has
lord.
been not deposited for the simple reason that the compensation is yet to be received by me. The officer in charge,
Rents are not deposited.
in fact,
vacating is not
my
done.
counterclaim of 75 lakhs is not considered by the trial court. If that is considered, there is no need to pay the rent at all, my lord.
Right, for counterclaim,
Counterclaim
is
is
no
not
appeal.
considered.
no court fee paid by.
75, I have paid the court fees.
Where is where
I
is
paid
the
the court
appeal?
fees. In
Which is
court-
the appeal? With regard to the rejection of the counterclaim?
Counterclaim, my lord could see at page number 62 of the trial court order, the impugned order. I paid the court fees. Additional
Page
numbers,
number?
page number 62, my lord.
What is the
Ink page
finding?
number 75.
What is the finding?
The finding is that I have to move the court for appropriate relief, and the trial court cannot grant that release of counterclaim. Though I have paid the court, it must be treated as a separate suit.
I mean, just a moment. Where is the finding with regard to the counterclaim?
Page number 62, my lord,
No. 60.
paragraph 82. Ink page 75. May I read the portion, my lord?
Stop it. Just the said amount on outstanding arrears of rent. So it shows that to prove the above said
It
condition.
is admitted fact.
Has not produced any supporting documents before this.
My lord, it has been, I have produced the documents.
Yeah, but
My lord, this is the evidence that is given by the other side.
where is the appeal from that?
My lord. The trial court comes to the conclusion that the respondent has not paid the amount that is due to me. In spite of coming to the conclusion that amount is due to me, the trial court says that I have not produced the documents. I have to approach the court for the necessary relief. Paragraph 82, my lord. Page 62, addition number 6. May I read that portion, my lord? I have produced the documents. Court also comes to the conclusion.
Yes,
My lord, may I read this for a particular paragraph, my lord? Paragraph 82, with regard to addition number 6, issue number 6.
you've
The
seen
defendant
that.
has contended in his written statement, and it is a specific contention that from 4/2/2020 to 26/8/2021, the plaintiff herein is due to the defendant for an amount of rupees 75,42,000 against the purchase order given to the defendant herein by the plaintiff. Further, it is the contention of the defendant that he and the plaintiff have mutually agreed to set off or adjust the said amount on the outstanding arrears of rent payable by the defendant to the plaintiff.
Have you filed an appeal as against that?
Yes, my lord.
Is there an appeal as against that?
This is the appeal I filed. ma'am. The counterclaim has not been considered by the trial court, and that is why I filed this appeal.
But the main prayer may be seen, my lord.
That is the reason why I filed this.
And
appeal.
kindly look at the decree, my lord. In the decree, the valuation slip at page 92, he has only paid 5,21,000 comparing to the decree. And in the decree that is passed,
Hmm.
look at column number 4, 2,42,545. But if he is contesting that, he must pay 5 lakhs, 7 lakhs.
That is not an issue raised by
42,000.
the trial court. In fact, I paid the entire court
As
fee.
of now, the time granted last time
Yes, madam.
was, the time was extended as a last chance for 2 weeks.
Yes,
You have
madam.
not paid.
Yes, madam.
Therefore, there's no interim order. Now it is only with regard to the hearing of the appeal. When will you be ready to hear the appeal on merits?
Today I am ready, my lord.
Any date, my lord. My lord, next week I'm ready. My lord.
Next week?
Next week I'm ready.
But,
Day will-
he does not vacate the premises. He does not use.
Let the matter be
When he
disposed
can't
on
pay the
merit.
rent,
In
how can
fact,
he use the premises?
This is termination.
It's a
notice
commercial
also is not
premises.
valid. In fact, the termination is, let it be heard on merit.
Second.
Next week, any date. madam.
Second September. Yes,
Okay.
for hearing. There is no interim order operating as against.
Yes, yes, madam.
Let him not take time in the executing court, my lord. Every time he moves.
There is no question of any time in the.
I'll
executive
abide
court
by the
now.
order of this. court.
There is no question of,
In fact, yes, madam.
it is,
Let this be heard on merit.
it is clear that the.
My lord, I have to receive compensation of nearly 1 crore.
it is
I'm
clear
unable to
that the
disclose the reason why I'm not getting that amount.
You don't get
I'm-
the amounts.
Applied with till date and no deposit has been made. It is therefore clarified that there is no interim order operating as on today.
Please.
List on second for hearing on the appeal. Yes.
20, Kavita Damodaran.
It's an IA for condonation of delayed solicitor, Your Lordship.
703 days in filing a commercial
703
appeal.
days. The reason is, Your Lordship, I am a company secretary of the defendant company. If I may narrate, Your Lordship, what has happened is I was part of the defendant one company and I was the company secretary. Later, I resigned in the year 2018. However, I was unaware of my signatures in the wakalats were presented to the councils and I was unaware these proceedings were going against me. Only upon the executing court passing an order as against me, I came to know of these proceedings. The reasons are forthcoming in the affidavit that I filed, Your Lordship.
Yes.
Page number 90 and
Please
91.
read 13(1)(a).
Any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial court within a period of 60 days from the date of the judgment or order. Your Lordship, I am aware of this provision. The only reason is it was not within my knowledge that such an wakalat was filed on my behalf in the commercial OS, Your Lordship. Your Lordship, page number 90 and 91, Your Lordship. In fact, WS was not filed on my behalf. A memo adopting WS of defendant number 1 was filed on my behalf, Your Lordship.
Notice is gone?
No, Your Lordship, this is the first date of hearing. Your Lordship, I may be permitted to take notice of the counsels appearing before the executing court.
In addition.
In addition.
21, Dhanlakshmi.
Here on behalf of the applicant, BDA.
625 days
Beg
delay.
yes.
Notice has been taken.
Can I make one request, madam? I'm sorry. In the first matter where Sushila madam is appearing, last time the copies were served on me just 4-5 days back. I couldn't prepare because of the
What has happened, my
vacation.
lord, is the auction, my lord, which he was a successful bidder, was cancelled by us, which, my lord, apparently we are not given any reasons. That, my lord, was challenged by him, and the learned single judge, my lord, allowed the writ petition, saying, though, my lord, we were, as per the auction notification, it was clearly mentioned that without assigning any reasons, and BDA, my lord, sale of corner sites and commercial sites, my lord, the regulation 7, which says that without assigning, we can do that. And, my lord, because it didn't fetch a little more than that. So it is for that reason. However, my lord, the learned single judge did not accept our contention, and my lord, allowed the writ petition, quashed the endorsement issued by us, and directed us to execute a sale deed, confirm the bid and execute a sale deed within 4 weeks. Now, small lapse on our part is, my lord, that while the writ appeal was pending, we conducted an auction and, my lord, and that now has been confirmed in their favor. And what has happened, my lord, is now the auction, my lord, that has been confirmed is virtually double the price. There, they had, it was, my lord, the price quoted by them, my lord, was about 5 crores and 67 lakhs odd. Now, my lord, it has been confirmed, my lord, that all close to 11 crores. So, my lord, there we had a thing that, my lord, because, and one more thing also, arbitrariness, Article 14 may not,
Whatever that be.
single judge's order was there.
Yes, when that was operating was when you conducted the second auction.
And that too, my lord, there is a clear order that we are supposed to confirm the bid and execute the sale deed without seeking the permission of the court, without getting any interim order by.
Second auction could not have been conducted at all.
4 times
No.
they conducted the auction. Post that, the first auction was in favor of Mr. Vijay Kumar's client. Post that price they conducted, and then now, my lord,
Yep.
I'm because-
Every time, my lord. Every time, my lord, every time when it was notified in paper, immediately I gave a representation telling the officers, please, there is an order staring at you. You please don't put up for auction. Nonetheless, my lord, they have gone ahead and conducted this and created this problem for everybody. Now BD has to solve this problem, my lord. I have
Right. How?
I'm requesting the laws that if they are, now there is a registered sale deed in my favor also, 11 crore rupees that I have paid, registered sale deed has, and I have dug the borewell, investing so many crores of rupees for that also. And when I was about to put up the construction, that shed, then Mr. Vijay Kumar's client comes and gives me this order. That's where there's a delay of maybe 2 years in me coming up with this order. My respectful submission would be this. DDA has to take the onerous responsibility. Now there is a sale deed in my favor. Please see if they can give one more site or something that could be given to Mr. Vijay Kumar's client and get silence, that would be wonderful. If not, Menas, where do I go now? I came all the way from US because of all these problems, Menas. Every month, 8,60,000 rupees I am paying towards EMI. And I wouldn't have purchased this at all if they had said that there is an order of injection. I mean, that's a clear order by the learned single judge. They have put me into suit.
No, the order of the learned single judge,
Very clear.
you could not have gone beyond it. Unless, of course, we find that there is something patently wrong about the order of the learned.
Yes, that, my lord, we would pursue your lordships and convince. But first hurdle, as your lordship said, my lord, I have to get over like how we could have gone ahead with that. But now it is already taken place now. There, my lord, like if your lordship sees a learned single judge, lord, now what?
Difficulty is with regard to the value of the property.
Yes, because
Now, you cannot, if as a matter of fact, it was only a matter of money spent, it could somehow be put back. But then the value of the property is so much.
yes. Now what happens, my lord, is, my lord, his right is not only to an extent only when the learned single judge passed the order. Otherwise, my lord, that 4 lakhs, the EMD, my lord, has been returned to him. It has gone to his account. Now, what happens is this, in that order, the learned single judge says that reasons have not been given, my lord. The other matter before, we have been service matters, we keep arguing, my lord. Mohinder Singh Gill's case, I understand. There, my lord, there they have a right. So it's on that basis. Here, what happens is, my lord, we have said very clearly in the tender notification, without assigning any reasons, we can either confirm or cancel the, my lord, the auction, whoever is the highest bidder. And our BDA regulation also says that we can do that. No, what it is said is that we are cancelling. They don't say the reason. And why I'm saying that,
When that was.
there is an order. Yes. No, my lord, just for a moment, my lord, forgetting that we have done this. And only the order of the learned single judge is before your lordships, my lord. There, what happens is this, my lord, he had.
As a matter of fact, do that. Is it open for this court to say that regardless of the order of the learned single judge?
What I would, my lord, I would only.
We are,
No,
we
no,
are
what I would, my lord, what I would only request, my lord, is ultimately, if your lordships, my lord, dismiss our writ appeal and uphold the order of the learned single judge, then, my lord, automatically the second thing would go. If your lordships were to hold in our favor, my lord, then
The first thing would go.
my lord, because there, my lord, I'll only make this submission. He had applied for two sites, 176 and the other one. There, my lord, we have confirmed. He's got that site. So, my lord, it is not with any malice or any malafide intention that we are doing something. So, my lord, Article 14 to that extent, we are not, my lord, because he's got it. So, my lord, 5% more there, whatever is the base price, it was more than 5%, which, my lord, we confirmed it in their favor. This one, my lord, it was less. All that, my lord, in that order, the BDA should have only put in a sentence that this did not confirm, and, my lord, but then, in this, my lord, whether it was required for BDA to have actually given that reason, my lord, or, and by looking into what it is, my lord, whether it could be done. My lord, do understand. That's why upfront, my lord, I brought it to your lordship's notice. Very clear order by the learned single judge quashing the endorsement, and second, not only confirming the bid, but to execute the sale deed. But, my lord, now this is the,
Can we hear the appeals on merits?
yes, my lord. Appeals on merits can be heard.
Therefore, the delay can be condoned.
Yes.
No. So far as the first matter is concerned,
Hmm.
granting leave to Sushila's client, I have serious objection because she was not a party. That's a subsequent cell. She steps into the shoes of the BDA. Therefore, that appeal, in the light of one Supreme Court judgment, I'll point out that appeal is not maintained. Another thing is, she has already filed a writ petition.
But
She's
what?
Challenging the order
challenging
of the learned single.
the entire thing and asking for certain prayers in the writ petition. That may also be tagged on. Independently, she has filed a writ petition under Article 226.
Everything else. Are you ready to argue
Not today, my lord.
BDA's appeal on your allotment?
Not today, my lord.
That will decide.
Yes.
Yes.
That's all is my request.
Decide the
Yes.
Not today, my lord. Your lordship may fix a date in the first week of September. I will do it.
Please.
Because I'll be traveling to.
You cannot seek any further time.
I
Because
understand.
that first have to be considered on the
Yes,
merits of the.
quite true. I'm on a MCPC training. I will not be here for a week or two.
Yes, the learned counsel appearing for the respondent in appeal 883 of 22 seeks a short adjournment. List next week.
Not next week. My lord. I'll be away till first week of September. Your lordship may accommodate.
List on
Fourth. Oh, only Monday.
second of the
Second.
calendar.
Endeavor of that, ma'am.
Thank you. 4th or 5th?
Yes, 4th or 5th is fine. Please.
Yes.
Great.
Please, on that day, please be ready.
Great.
Please.
I'll complete my
Yes.
training work and come back. ma'am.
Yes.
Obliged.
In the meantime, in the meantime, my lord,
Await this. If this goes either way,
Yes.
then your appeal will have to be considered on its merits.
it will follow the result in the first this
Yes.
appeal, my lord, 883.
Of course, it'll be,
After this is 883 is heard.
we'll definitely hear you.
After 883 is heard, my lord, that can also be heard simultaneously. No difficulty. In the meantime, I'll also file the pleadings, objections. and all that.
883 also,
Yes,
the subsequent purchaser can be heard. for-
no problem.
for
I'm not,
appeal.
I'm not
Yes.
standing on any technicalities. my lord.
Yes.
I'll point out some judgments of the Supreme Court.
22nd. I appear for the appellant in this matter.
Yes.
Here, I have.
I am appearing for the respondent, madam.
Yes.
In the morning, I mentioned, my lord,
Yes.
just accommodation, my lord, in this matter, in the next week, 29th, my lord. 29th.
Can be
Lord, today, my lord, execution petition is listed today.
that we, it was because you were not here that we. said it.
29th, madam.
Yes, list on 29.
It's, well, learned friend may be requested whether the presence of the
Notice to-
DC is necessary, but DC and the
But-
AC.
My lord, they are formal parties, my lord.
Issue
Issue number
notice to-
2 and 3 formal parties, and issue notice.
I'll take notice, madam.
My lord, otherwise, my lord, I mean, if my lord, my learned friend is here, if my lord, it's a very small point of marriage, so then my lord stay, I mean, I am looking for stay, my lord. Lord, execution is pending.
29th, my lord, we will mention all things, please.
It's on 29. So and so.
Lord, I have,
this
Lord,
was
just one,
2 and 3.
Lord, we have requested for dispensation of production of certified copy of arbitral award, that IA 1 of 2024. Because, my lord, that original certified copy of arbitral award was filed along with arbitration petition.
Consider it on 29.
Please.
Passed on matter. Seal number
Yes.
3, Mubarak Begum.
Please, your lordship. Yes.
May it please your lordship, as my lordship heard the arguments of my learned friend, matter relates to a Section 8 application that was filed in Commercial Suit 1310 of
Yes.
2023. The application came to be dismissed by the impugned order.
Yes.
My lords, there are three objections I have raised to this Section 8 application. I'll
Just a moment. Yes.
Please, my lord. My lords, I have raised three objections to this Section 8 application. The first is that there is a non-arbitrable claim that has been raised in this application. My lords, briefly, the subject matter of the suit and the subject matter of the arbitration clause contained in the agreement are different. My lords, my second objection is that there is a non-arbitrable dispute that has been raised. This suit deals with intellectual property rights, and the same are not subject matter of arbitration. And my lords, my third objection is that the Section 8 application has been filed only after filing the first statement of dispute as mandated by Section 8. My lords, these were my three objections that I'll be covering. My lords, regarding my first objection, that there is no arbitrable claim between the parties, my lords, I'll just briefly draw reference to the fact that the party herein, I represent a music label or my artist who had entered into 2 agreements with 5 band members of the band Mother Jane. These 2 agreements were both entered on the same date, which is 30th August 2008. My lords, one of the agreements is an assignment deed. By the virtue of this assignment deed, intellectual property rights of the band Mother Jane were assigned to me, that is the music label. The second agreement is a deed of agreement by which I entered into an agreement for production of 5 music albums and for the band members to act as authorized artists. Now, the appellant before you are 2 of the band members out of the 5 who had entered into these agreements. My lords, I'll just, although my learned friend referred to that part, but I'll just would like to take my laws to the prayer that has been sought in the commercial suit because it will clear the dispute between the parties. The prayer can be found at page 181 of the appeal paper book. This is the plaint that I have filed before the commercial court. It starts at 165, but I'm just taking my laws to 181, which is the prayer that has been sought. The prayer section at the bottom of the page, prayer A, an order for permanent injunction restraining and enjoining the defendants, their partners, principal officers, servants and agents, and all others acting on his behalf as the case may be, from utilizing Mother Jane, which is the trademark, and any other deceptive similar mark belonging to the plaintiff by virtue of the deed of assignment dated 30th August 2008. I'll draw emphasis here that I derive my trademark rights pursuant to the deed of assignment, which does not have an arbitration clause and has been filed in this appeal as well.
Deed of assignment dated 30th August 2008.
2008.
That, according to you, does not contain a.
That is the admitted fact that there is no arbitration clause in the deed of assignment. Similarly, my lords, I won't read the entire prayer B, but prayer B also seeks an injunction from not utilizing the songs of the band Mother Jane pursuant to the deed of assignment dated 30th August 2000. That is clearly reflected in prayer B, the last line. And your lordship, just for the sake of completion over the page, my prayer C is for damages pursuant to the infringement of trademark and copyright. So these are the three prayers that I have sought before the trial court in commercial OS 1310. There is no other relief that has been sought by me. Lord, I'll just draw your brief reference to the assignment deed itself, because it records the intellectual property rights which are the subject matter of dispute.
When was the trademark, the name registered?
It was registered in soon after this deed, but admittedly that trademark has expired. I have filed another application last year, which is pending for consideration. The assignment deed can now be found at page 68 of the appeal paper book, Annexure C.
Yes.
Okay. Thank you. Admittedly, there is no arbitration clause in this agreement. Second, the subject matter of this agreement is very clear as well. From, if my lords have page 69 over the page.
The assigner is,
Has agreed to assign. May I read out?
just a moment. The assigner is the executive individual also represented by its members. Members of the band are the assigners.
Yes.
First part.
Yes.
And the assignee is you.
Me. And two of the band members who are mentioned in this deed
Just a
are
moment.
the appellants
Represented-
before you.
The assignee is your company,
Yes, ma'am.
represented by managing director.
Yes.
Yes.
Over the page, the top recital at the top of the page, I'll just read out because that gives what is the subject matter of this agreement. Whereas the assigner has agreed to assign all the intellectual property rights of the above named musical compositions, lyrics, songs, audio, and visual works of the band called Mother Jane, as more fully described in schedules A and B hereunder, for use to the assignee, and the assignee is also desirous of getting all the intellectual property rights of the above works of the assigner for using the same for all his business activities for the various goods and services offered by the assignee. And these intellectual property rights can be seen at page 46. Schedule A refers to the trademark Mother Jane, and Schedule B refers to all the songs. It continues for a few pages after that. All the songs which have been produced for the band Mother Jane, which were produced by the band Mother Jane up to the year 2008. My contention here is my suit has been filed for violation of this trademark and copyright arising from this agreement. My lords, separately there is a, beg your pardon. There is a separate deed of agreement.
What does that say? What is that about?
That deed of agreement is for production of 5 music albums, which can be found at
That
page,
is also same day.
same day,
Same day.
same day. Page 59 is the deed of agreement.
Document number 7.
Document number 7, Annexure B in these present proceedings. Document number 7 comes from the
Annexure B.
trial court reference.
Yes.
If my lord, should I read out the recital which will describe this?
Not all, but
The relevant.
what does,
aspect,
yes.
yes. The does, the recital, the first recital at page 58 at the bottom clearly states that whereas the party of the first part, the company is engaged in a business relating to the music industry and has approached the above named party of the second part to sign on band as the authorized artist for a period of 5 years from 2nd April 2008 on the terms and conditions as mentioned below. And the above named party of the second part, Mother Jane, has agreed to sell the full copy of rights and other intellectual property rights whatsoever over the page. Aforesaid party of the first part and the company on a consideration has mutually agreed upon and has stated as under. I'll just read clause 3 because that records the.
Yes.
Clause 2, the party on the same page. The party of the first part, the company shall have the rights to record albums of Mother Jane in any format as decided by the party of the first part. the company and the intellectual property rights for such works shall vest with the party of the first part, the company. My lords, what is
That
happening
the
is,
record the albums of Mother Jane in any format
yes,
and the intellectual property rights for such works.
yes. So what has happened up till 30th August 2008, 2 albums have been produced and some songs have been released, for assignment of which is dealt with the assignment deed. Separately, I'm also entering into an agreement wherein 5 more albums would be had to be produced by the band members, and those intellectual property rights arising from those albums would be also assigned to me.
Hmm.
And I'm also agreeing to pay 1,20,000 per year to each of the 5 band members,
Hmm.
as recorded in clause 3. During the tenure of the agreement, the party of the first part, the company shall pay an annual remuneration of rupees 1,20,000 to each individual member of the party of the second part, Mother Jane, as consideration, that is 6 lakhs for the entire band, inclusive of all taxes that have to be compiled.
Hmm.
Admittedly, there is an arbitration clause which is part of this agreement, that is clause 31.
Hmm.
My lords may want to refer to it. It's at page page 65 of the appeal paperwork. Oh, sorry, I beg your pardon. 66. This is the arbitration clause which was.
Hmm.
And my lords, for a moment, I'll also like to draw my lord's attention to the prayer that has been sought in the Section 8 application filed before the trial court.
Just a moment, shall we see this clause, paragraph 28? No, 31.
Please, ma'am. May I read out for my lord's
Please,
convenience?
please.
In case any dispute between both the parties of the first and second part, the same shall be resolved through arbitration. For the purpose of holding such arbitration, it is mutually agreed between the parties that the arbitrator shall be Mr. R.P. Ramanathan, BCom, BL, PG, DBA, advocate at door number 203, second floor, Kasturi Nagar, second main, Bangalore 560043, who will conduct the arbitration proceedings in accordance with the Indian Arbitration Act 1996, and the arbitration shall be held at Bangalore and the language shall be in English. The decision of the above arbitrator shall be final and binding on both the parties to this agreement, and no case shall lie before any court of law. Well, I'm digressing here for a minute, but pursuant to this arbitration clause, there was an arbitrator was appointed by me. I initiated the arbitration proceedings. However, the appellant, and rightly so, objected to the arbitrator because he had acted as the trademark agent for me in the past. Once that objection was raised, the arbitrator resigned and the proceedings came to an end. Subsequently, I received a notice of arbitration from the appellant asking to initiate arbitration proceedings. They had proposed a certain name. I refused that name, and I said that let a joint reference be made to the Arbitration and Conciliation Center, Bangalore, for any arbitrator to be appointed. However, there's been no response to that from the appellant. And separately, CMP proceedings are also pending, which has been highlighted by my lord. Only for the sake of completeness, because we were looking at this arbitration clause.
Your contention is that the arbitration, if any, under this agreement would be confined to the 5 albums mentioned there.
Production of music albums, as well as any damages that either party, because these 5 albums were never produced. It's an undisputed fact by the band.
Oh, they were never.
The band disintegrated after 2008, as it existed in 2008. However, the band continues to perform today, and I, as a music label, have authorized artists who are performing under the band trademark Mother Jane, as well as performing the songs which are a part of the site. Well, this is only, I digress here on the arbitration clause, but my principal objection is that there is no arbitrable dispute between the parties, because the arbitration clause exists within the deed of agreement, whereas assignment deed is a separate agreement dealing only with assignment of IPR. In my suit that I have filed before the commercial court, I'm only seeking the remedy of injunction against the infringement of trademark and copyright by the appellant, as well as damages pursuant to that infringement. I have not raised any dispute in the suit regarding the production of the 5 albums or the amounts that I had paid to to them under the deed of agreement. My lords, even the appellant before this court, in his Section 8 application, is only seeking remedy concerning the intellectual property rights.
Where is the Section 8 application?
It's at page 190 of the appeal paperwork, my lords. My lords have it. Page 190 of the appeal paperwork.
Yes,
I'll just read these 3 lines because it will clear the dispute that has been raised by the appellant.
yes.
For the reasons sworn in the accompanying affidavit, the defendants most respectfully pray before this honorable court, may be pleased to refer the above matter to arbitration, as there is a clear clause of arbitration in the agreement titled Deed of Agreement, clause 31 of the said agreement, dated 30th August 2008. So my lord, the prayer and subsequently the application that also follows is completely premised on the arbitration clause existing in the Deed of Agreement. And my lords, if my lords may want, I can read aspects of the application which would highlight this aspect further. This aspect can be again found in para 17 at page 201 of the appeal paper book,
Yes.
where I further state, as per clause 31 of the said agreement, the plaintiff has initiated the arbitration proceedings and appointed the sole arbitrator named in the said agreement, and the defendants have duly participated. My lords, this is the aspect where I was referring to, where and then I may please see para 21 over the page at 203.
Yes.
I further state that the claim of the plaintiff is only based on the assignment deed, which is covered and governed by the arbitration agreement as per clause 31 of the said agreement. My lord, there is no arbitration clause in the assignment deed, so the reliance is only on clause 31 of the deed. My lord, and the difference between these two agreements has also already been observed by the learned trial court. So I had filed an application for injunction, and there was an application filed for vacating the stay, which was filed by the appellant. Those applications were disposed of by order dated 7th Feb 2024 by the learned trial court. This contention was also raised at that time regarding these two agreements, and there is a finding that I would just like to briefly read, just one paragraph, just to show. This is a part of my objections, my lords. This order has not been filed along with the appeal paper book.
Yes.
Page 46 of my objections. So this is the order dated 7th Feb 2024, which starts at page 30, annexure R1. I'm just drawing reference to para 24 at page 46.
Yes.
May I read mine?
Yes.
The other contention raised is that the suit is not maintainable in view of the arbitration clause. However, the arbitration clause is contained in the agreement between the parties and not in the assignment deed. This is a suit based on violation of trademark and copyright assigned to the plaintiff under the deed of assignment, and the present suit does not arise out of other contract entered into between the parties, which is also dated 30th August 2008, under which the music band agreed to produce 5 albums in 5 years. May I request my lawyer to turn over the page?
Yes.
Benefit of the plaintiff, and the plaintiff agreed to pay a sum of rupees 1,20,000 per annum to each member of the band for a period of 5 years. Therefore, the present suit having nothing to do with the other agreement containing the arbitration clause, it cannot be said that the present suit is barred in view of the arbitration. My lords, this is my first objection. There being no valid arbitrable dispute between the parties, and there is a non-arbitrable claim.
Yes.
My lords, my second objection is that there is no valid arbitrable claim that can be raised in the matter. My lords, because my suit for infringement deals with infringement of trademark and copyrights. My lords, it's no longer esse nigra that IPR disputes are not arbitrable. There are some judgments just for reference that I'll refer to, although the issue I don't believe would be objected to by my learned friend as well.
Yes.
as my laws just saw, my prayer deals with infringement and infringement of trademark and copyright both. Although there are two judgments I'm relying upon, which clearly declare that IPR disputes cannot be arbitrated, even if consented to by the parties. Either the first judgment is the Supreme Court judgment, which is at serial number 4 in the index, Vidya Drolia and others versus Durga Trading Corporation. Others, I'll just draw reference to para 49, which is at page 144 of the compilation.
Yes.
I'll just read out para 49 from
49.
yes. Exclusions of actions in rem from arbitration exposits the intrinsic limits of arbitration as a private dispute resolution mechanism, which is only binding on the parties to the arbitration agreement. The courts established by law, on the other hand, enjoy jurisdiction by default and do not require mutual agreement for conferring jurisdiction. The arbitral tribunals, not being courts of law or established under the auspices of state, cannot act judicially so as to affect those who are not bound by the arbitration clause. Arbitration is unsuitable when it has an erga omnes effect, that is, it affects the rights and liabilities of persons who are not bound by the arbitration agreement. Although this is also the ratio that is frequently relied upon to say that intellectual property rights are not the subject matter, cannot be the subject matter of arbitration. Equally, arbitration as a decentralized mode of dispute resolution is unsuitable when the subject matter or a dispute in the factual background requires collective adjudication before one court or forum. So, I'll just move to para 50 now because there's a specific reference that has been made. My lords, I'll just read from the beginning, but the line that I'm drawing reference to is down the paragraph.
Yes.
Sovereign functions of the state being inalienable and non-delegable are non-arbitrable, as a state alone has exclusive right and duty to perform such functions. For example, it is generally accepted that monopoly rights can be granted by the state. Correctness and validity of the state or sovereign functions cannot be made a direct subject matter of the private adjudicatory process. Sovereign functions for the purpose of Arbitration Act would extend to the exercise of executive power in different fields, including commerce and economic legislation in all forms, taxation, eminent domain, and police powers, which includes maintenance of law and order, internal security, grant of pardon, as distinguished from commercial activities, economic adventures, and welfare activities. Similarly, decisions and adjudicatory functions of the state that have public interest element, like the legitimacy of marriage, citizenship, binding up of companies, grant of patents, etc., are not arbitrable unless the statute in relation to a regulatory or adjudicatory mechanism, either expressly or by clear implication, permits arbitration. My lords, there is no specific clause within the Trademarks Act or the Copyrights Act permitting arbitration. My lords, there are other paragraphs which repeat the same effect. For instance, observations were also made in the judgment of A. Ayaswamy versus A. Paramsivam, 2016 Supreme Court. I'll just draw reference to page 22 of the compilation for para 14.
Yes.
In the instant case, there is no dispute about the arbitration agreement in as much there is a specific arbitration clause in the partnership deed. However, the question as to whether the dispute raised by the respondent in the suit is incapable of settlement through arbitration. As pointed out above, the Act does not make any provision excluding any category of disputes, treating them as non-arbitrable. Notwithstanding the above, the courts have held that certain kinds of disputes may not be capable of adjudication through the means of arbitration. The courts have held that certain disputes like criminal offenses of a public nature, disputes arising out of illegal agreements, and disputes related to status such as divorce cannot be referred to arbitration. The following categories of disputes are generally treated as non-arbitrable. Number 1, patent, trademarks, and copyright. Although this is a division bench judgment of the Supreme Court, considering Justice Sikri and Justice Chandrachud as he then was. So, my lords, these two judgments I'm relying upon for the proposition that IPR disputes cannot be arbitrated.
Yes.
Even if I was consenting to the arbitration under the assignment deed, they could not have been referred as IPR disputes cannot be arbitrated by any arbitrator under law.
What is the finding of the commercial court?
allows the commercial court's finding relates to the third objection, which is that the Section 8 application has been only filed after the filing of the first statement of dispute.
That is all that is.
That is all that the given order is premised on. And the second aspect that has been covered by the commercial court's order is that there is no certified copy or the original arbitration agreement that has been produced by the appellant, which is a requirement under Section 8(2).
Yes.
My lord, just for reference, the dates are that the written statement was filed by the appellant on 3rd of January 2024, once the appearance was entered into. And the Section 8 application was only filed
Written statement on?
3rd of January 2024. The written statement was filed.
Yes.
Whereas the Section 8 application was only filed on 6th of March 2024. The order sheet has been produced by the appellant, so this is undisputed. My lords, the written statement is a voluminous written statement covering more than 44 pages, answering the matter on substance of dispute. Although I'll fairly concede so that the objection regarding this arbitration aspect has also been raised in the written statement as a separate paragraph. However, it was filed much belatedly going into the Section 8 application was filed much belatedly. My lords, the last aspect, which is that there is an injunction order which has been passed in the matter on 7th of February. And my learned friends' clients have been openly violating it ever since that order has been passed. But that is a subject matter of separate disobedience proceedings. But concerning their conduct, I wanted to highlight the same.
Yes. Yes, what do you say?
My lord, regarding the deed of agreement, whether the assignment deed is governed by the deed of agreement or not. My lord, I have produced the IA for additional document, wherein I have produced certain documents, my lord. May I please request your lordship to. I have
What
filed
was-
my IA for additional document on.
What was your contention in the written statement before? the
Yes,
commission?
my lord, in fact, the deed of agreement or the assignment deed, both are on the same date it was executed, and both are interlinked and covered by this deed of agreement. In fact, the appellants, the defendants, I'm sorry, my lord, the plaintiff who has initiated the arbitration proceedings was the first. At the time of initiating the arbitration proceedings, my lord, this very similar relief, it has been placed before the arbitration proceedings, my lord. And there is no distinction between the commercial suit or between the arbitration proceedings, my lord. May I please, your lordship may kindly, for a moment, my lord, kindly look at the IA for additional document which I have produced, wherein the section, an interim application filed by the plaintiff before the arbitration proceedings under Section 17 I have produced, my lord, wherein they have taken the clear contention, my lord. Page 18, my lord. Page 18 of the application, my lord. Para number 15, my lord. This application was filed before the arbitration proceedings, my lord, under Section 17 by the plaintiff. May I read, my lord? Para 15. In conjoint reading of the deed of agreement and assignment deed, both of which are executed on the same day and between the same parties and before the same witnesses, would show that these agreements are interlinked and are to be read together. And the relief sought is based on the assignment deed only, my lord. Repeatedly, they have in their pleadings mentioned that the defendants have violated the assignment deed and they have infringed their rights by using the trade name Mother Jane and by using the same very similar music composition. Other than this, there is no other dispute, my lord. Only in addition to this dispute, my lord, before the commercial suit, they have asked for the damages. But before the arbitration proceedings, my lord, this is the very similar dispute they have raised. And they cannot make so once the dispute is raised. Now they cannot say that this is entirely different proceedings and before the commercial, before the arbitration proceedings are the entirely different proceedings, my lord. My lord, this entire IEA, my lord, may I read the prior of this interim application, my lord?
Yes.
Page 28 of this IA for additional document, my lord. Wherefore, the applicant prays that this honorable court, arbitral tribunal may be pleased to pass the following orders. Direct the order that first and second respondent herein, Mother Jane Music Production LLP, which is a partnership firm floated by the first and second respondent herein, by way of temporary injunction to refrain from using the word Mother Jane in any form and manner and from representing themselves as being entitled to own and perform under the name Mother Jane pending disposal of the arbitration proceedings. The next prayer, my lord, restrain the first and second respondent hearing and Mother Jane Music Production LLP by way of temporary injunction from entering into commercial relationship with other organizers for performing live shows and restrain the respondents from assigning the marketing rights of the rock band Mother Jane, which is owned exclusively by the applicant. The next prayer, my lord, restrain the respondents herein Mother Jane Music Production LLP by way of temporary injunction from using the copyrighted materials that is assigned to the applicant by way of the deed of agreement, assignment deed dated 30th August 2008, pending disposal of the present arbitration proceedings. Therefore, my lord, it is clear, my lord, the very same prior has been sought before the arbitration proceedings. Now they cannot say that it is a totally copyright and it's related to the patent and the arbitration proceedings cannot be conducted. The very same relief they have sought before the arbitration proceedings, my lord. And para number 4, my lord, restrain the prior number 4, my lord, restrain the respondents hearing and Mother Jane Music Production LLP by way of temporary injunction to restrain them representing themselves as owners or users of the brand Mother Jane in any forum, including social media forums, and to immediately remove any such posts already uploaded by the respondents from their social media profits. These are the priors before the arbitration proceedings, my lord.
Yes.
And my lord, they have also, for claiming these reliefs, they have strongly relied on the assignment deed, my lord. In their pleadings, they have reiterated the facts that the assignment deed has been violated by these defendants by using the name trade name Mother Jane and by using the very similar music compositions, my lord.
In response.
My lord,
Stone.
Please.
in page 22, my lord, para 28 of the said application, my lord, the pleadings of the plaintiff before the arbitration proceedings, my lord. Page 22, my lord, para 28, my lords. Upon receiving this notice conducting some subsequent research, the applicant realized that in sheer violation to the terms of the assignment deed, the first and second respondents have floated a limited liability partnership firm in the year 2019 here in the name of Mother Jane Music Production LLP. It became clear to the applicant that this was done with a motive of willful violating both the deed of agreement and assignment deed. It is pertinent to mention that first and second respondents never recorded the 5 albums for the applicant company as agreed upon in the deed of agreement. In fact, my lord, the high reliance was placed on the assignment deed. Without claiming any reliance on the assignment deed, they have not sought for these reliefs, my lord. Both the reliefs and both the disputes are one and the same, and it is similar in nature, my lord. And my lord, though I have filed my written statement, in my written statement, I have taken clear pleadings about the filing of the CMP, which is for appointment of the arbitration, which I have filed, my lord, that is also I have produced along with my written IA for additional document, my lord. Page 33, my lords. which I have filed on 4/12/2023, my lord, the filing date of the CMP. 4/12/2023, I have filed, seeking the appointment of the arbitration, my lord, arbitrator, my lord. 4/12, page 33 of my application, my lord, IA for additional document, wherein the filing date for the CMP petition is on 4/12/2023, my lord.
Yes.
In fact, my lord, I have not waived my right to proceed under the arbitration, my lord. I have continuously pursuing the matter, very seriously, to appoint the arbitration, under the arbitration, my lord, by filing CMP petition. And this fact also brought before the commercial court, my lord, along with my written statement, I have produced as one of the document, wherein I have stated that CMP petition is pending. Therefore, I have requested the court, my lord, and these facts I have brought before the commercial court, my lord. My lord, on the last date of hearing, my lord, due to the error in pagination, the judgments what I have relied has been written. I may be permitted to furnish to them. Last. Very soon.
Very safe.
Yes.
My lord, I have produced the judgments, my lord. The second judgment, my lord, which starts at page 11, my lords, the division bench of Honorable Delhi High Court, my lords, wherein the similar issue has been discussed in detail, my lord, whether the pleadings, whether the filing of the Section 8 application at the very first instance is necessary, or only taking the pleadings in the written statement is suffice. My lord, it is clearly discussed in detail in this judgment, my lord. I may be permitted to refer this judgment, my lord. My lord, page 30 of the said judgment, my lords. In this judgment, my lord, mere absence of prayer to refer the dispute before the arbitration cannot come in the way of judicial authority to refer the matter to arbitration, my lord, which is clearly discussed in this judgment, my lord.
Yes.
Please, my lord.
What is it that you refer to?
My lord, I referred page 30 of this, my lord.
Page 30?
Page 30, para 38, my lords. From line 3, my lord, I am reading, my lord. May I be permitted to read, my lord? The division bench has clearly held that even if there is no specific request to refer the dispute between the parties to arbitration, the raising of an objection to the effect that suit is not maintainable in view of the arbitration clause can be read as an implied request to refer the dispute to arbitration.
That is not the question that we are considering here. The question is whether the request made under Section 8 is belated or not. That is the finding you are attacking.
Yes, my lord. In this judgment, my lord, the very same question has arisen, my lord. One is the application is filed belated. Another one is this.
When exactly was your written statement filed?
My lord, I filed my written statement, my lord. Immediately after coming on record, my lord, I filed my written.
When was it filed is the question.
Please, my lord.
If I may assist, 3rd January 2024.
3rd January 24.
24.
Section 8 is filed on, according to them, 4/12.
March.
6th of March.
6th of March 2024.
Section 8 is only on 6th of March.
Yes, my lord.
So what was the application you filed on 4/12/23? 4/12/23, you showed us an application you filed on 4/12/23. What was that?
That is my civil miscellaneous petition, my lord, before the Honorable High Court of Karnataka to seeking an appointment of the arbitrator, my lord. Immediately after I issue the notice of dispute, my lord, then, my lord, the plaintiff has replied refusing my name, the name suggested by me. Immediately, I have filed the petition to refer, seeking an appointment of the arbitration, my lord. And
With
that
regard to
was,
what, where is that IA? Where is the IA?
my lord,
Where is the CMP? I'm sorry.
CMP case status I have produced along with my
The
IAM.
case status, where is that CMP?
CMP is
Your
pending now, my lord.
What was your prayer in the CMP would be the question. Are you referring to the deed of assignment or the agreement?
I am referring to the deed of agreement, my lord.
Yes.
Deed of agreement, my lord.
Yes, therefore admittedly written statement was filed in January 2024. And the section 8 petition was in March 2024.
Please, my lord. Even if,
Which is the decision which you rely on to say that the contention taken in the written statement will suffice?
Suffice, my lord.
Where is that?
Please, my lord. My lord, this judgment passed by the Honorable High Court of Delhi, it starts at page 11, my lord, where in this judgment, my lord, it is clear, detailed discussion has taken place, my lord, regarding the similar issue, my lord. My lord, wherein I am relying on certain paragraph, my lord, without wasting of this Honorable Court, my lord, so that I can
Where is the
straight away
finding?
come to.
Where is the finding that
Please, my lord, I'll
contention
come
taken
to
in
the
the written
finding.
statement will
Please, my lord.
suffice?
Page 31, my lord. There are several, may I read, my lord? The next question for consideration, my lord, the extraction taken at para 15, my lord, in page 31. The next question for consideration is whether the making of an application under section 8 is necessary or the plea substantially of section 8 in the written statement suffices. Though section 1 of section 8 merely talks of if a party so applies, and which can also be in the written statement, but subsection 2 and 3 of section 8 do mention an application under subsection. However, in my opinion, the legislative change as contained in section 8 of 1996 Act, as from section 34 of 1940 Act, is not indicative of an application separate from the written statement being necessitated to be filed for invoking arbitration agreement between the parties. In fact, even in the Aarti Jethani, it has been held that reference under section 8 of the parties to arbitration can be made if the written statement itself contains a prior for referring the dispute for arbitration. However, Aarti Jethani, to the extent it holds that there has to be a specific prior for reference with due respect to the judgment in Aarti Jethani, is contrary to the mandate of section 8. Section 8, as aforesaid, merely requires a party to action before a judicial authority to bring to the notice of the judicial authority that action brought before the judicial authority is the subject of an arbitration agreement. As long as the same is done in the written statement, mere absence of a prior or use of the words seeking reference to arbitration cannot come in the way of obligation of the judicial authority to refer the parties to the arbitration.
What matters is whether there is in fact an arbitration agreement between the parties which is valid and subsisting. If such an agreement is in place, jurisdiction of the civil court to hear and adjudicate subsists only so long as it is. Its attention is not invited to the arbitration. Yes.
My lord, in page 32, my lord, there is one more observation, my lord, with regard to with regard to the pleadings, whether it has been appropriately pleaded or not. May I be permitted, my lord?
Yes.
Page 32, my lord, para 19.
We've seen that, Council. We've
Yes,
seen
my
that.
lord. Even
Yes.
if the language,
Here-
instead of referring the matter.
There is no question of the language because you have pleaded in your written statement.
Yes,
You have
ma'am.
also filed the application.
Yes, ma'am.
Hmm.
Only my application was rejected only on the two grounds, my lord, which is filed because it's filed belatedly. And the other ground is, my lord, I have failed to produce the original arbitration agreement, wherein I have already pleaded in my application that our original arbitration agreement is in the already before the court, honorable court, which was produced by way of memo by the plaintiff himself. And that was ignored. My contention, my pleadings have been ignored. But still, the Honorable Commercial Court proceeded to reject my application, my lord, by ignoring this.
What do you say on this contention that even if both of you agree, an action with regard to infringement or passing off is not referable to arbitration at all, cannot be considered?
My lord, regarding this judgment, my lord, regarding this judgment, my lord, the plaintiffs has already initiated the arbitration proceedings, my lord.
Which is the specific contention that prayer may have been taken by him in the arbitration proceedings also. Inter se between you. You admit that this suit now filed is for infringement and passing off, or infringement per se on the basis of the assignment.
Yes, my lord.
Therefore, if it is a suit for infringement of a trademark, the contention is that the dispute as such per se is not arbitrable. His having acquiesced or his having sought a prayer in the arbitration proceedings would make no difference to that, because what is being considered is a suit for infringement. What do you say to that?
My lord, maybe, my lord, but in this matter, my lord, there is a clear arbitration clause is there between the parties.
Arbitration clause cannot help you in so far as a specific plea. Suppose there's an arbitration clause in a rent deed. Suppose there is an arbitration clause in the rent deed. Will that confer a right on you to say that it is to be the dispute is arbitrable and the Lease and Rent Control Act has no application?
My lord, to answer this, my lord, this judgment, my lord, I will go through this judgment, my lord. Kindly have it on next week, my lord.
There is an interim order
Yes.
operating as against you.
Yes.
We list this on only on this aspect, even if everything else is admitted.
Yes,
If
my
it's
lord.
an infringement
Yes,
suit,
my lord.
will arbitration lie?
Whether it is applicable or not, my lord, I would demonstrate.
Can we have this on the 23rd, this week itself?
Please,
Only on this point.
please.
Yes.
Meantime, interim order may be extended.
Till then, nothing is happening. Till then, nothing is happening. 23rd. Friday.
23rd. Yes.
Rajshekar?
Great.
Not apply again. Your patient here.
Notes among
Grant was 15 guntas.
15 guntas in favor of the appellants and the fourth respondent.
Saguvalli chit for 1 acre, 5 guntas.
Please note, the
set aside.
fourth respondent without the knowledge of the appellants herein makes an application for mutation of 1 acre 5 guntas
saying that she is in possession of 1 acre 5 guntas, and my lords, that has been allowed, against which I preferred an appeal to the Assistant Commissioner, and an order is passed at Annexure T, against which my lords, writ petition was filed, and writ petition is allowed, holding that my lords, she is entitled for 1 acre 5 guntas. My lords, my humble submission before this honorable court is, my lords, there was an inquiry held at the first instance.
May I make one sub?
Yes,
That with regard, no,
the records of.
records, my lord.
You've
that
seen the records.
Previously, that record has been, we have, myself and my learned friend has seen.
Yes.
That subsequently there is a book with regard to that, the resolution book is there. That I made a submission, that book is to be called for. So therefore, on the last occasion, it is directed to secure that record.
No, just a moment. What is the records for the committee for regularization?
That the committee, resolutions committee, it is to be secured. my lord.
Was it in respect of 15 guntas or
Yes.
was it in respect?
It is in respect of all the
Applicants,
grant,
all the applicants.
all the applicants. So
Hmm.
therefore, that it requires, therefore I made a submission on the last occasion.
There were 3 applicants.
No,
Totally,
the total
29 applicants, my lord.
32
In
applicants are
respect of
there.
this writ
It's
petition,
only in respect of
parties-
3.
Parties are 3.
It is
Yes.
only 3.
All of them, according to you, were granted 15 guntas each.
Yes.
According to that, the 15 guntas, my lord, that I have challenged it.
Hmm.
And thereafter, the matter was remanded.
Hmm.
Subsequently, I have been granted 1 acre 5 guntas.
Hmm.
That particular register,
Is the
yes, my lord,
aspect.
that the particular register, my lord, it was made available before before the learned single judge.
Hmm.
That on the last occasion, I made my submission, that registry is to be secured.
Hmm.
That it is directed that the government to secure that register.
That
If
is
it
not
is,
here.
it is not a trade, but this is.
Grants committee register, grants committee records, my lord.
Records of the committee for regularization, including the resolution.
Subsequent resolution.
Subsequent resolution.
Resolution.
1992, which they have.
No,
declared
it is
on
there.
10/7/1992.
Subsequent.
That is the record which I have.
Original record.
That is with regard to,
There
that,
are
just a moment, Government Advocate, that the first resolution was with regard to 15 guntas.
Yes.
Yes.
Respect of all.
Yes, my lord.
He had approached this court. I mean, he had
I preferred an appeal
he had preferred an appeal, it was remanded. Thereafter, there was,
in 2000. So that resolution we require.
is that available?
In 2003, my lord, that it's, that is all the question.
That is with regard to my lords, annexures B to J. That is what
Sir?
annexes B to J. Those are the documents, my lords, according to me, which are all concocted in collusion with the my lords, third respondent.
Is it available is the question.
Presently, they are not available.
That register because.
Register is there.
ಅದು ಅವ್ರ ಹತ್ರ ಇದೆ. It is available with the government.
Yeah, I can secure that particular register if it is available. But I am also not aware what is available and what is not.
No, because
If this is.
before the learned single judge, my lord, that the register has been produced and in the impugned order, it is stated so.
Where does it say so?
So that in the impugned order, my lord, that
Annex.
at page number 17, my lord, para 2,
Government Advocate produce the original proceedings.
Original
relating to the
proceedings.
Orders passed by the committee for regularization.
yes, my lord, that
In this, it is noticed that pursuant to a survey conducted, it had been found that the petitioner was in possession of 1 acre 5 guntas of land. And therefore, she was entitled for an order of regularization in respect of 1 acre 5.
5 guntas. That
Which is the order of the order at Annexure T, which grants. the
Annexure
20
T is the my lords,
Annexure
order
T,
passed
my
by
lord.
the
Is there a,
mentioned
No,
lords. yes,
Annexure
lords.
T,
Annexure T was the order by which that was cancelled.
Cancelled by
Annexure
the High
M, my
Court
lord,
in the writ petition.
previously the annexure M was passed,
M,
rejecting the appeal filed by the appellants herein.
yes.
Then subsequently, they filed an application under section 20 of the Karnataka Land Revenue Act to review the case.
Hmm.
That thereafter, my lord, they produced certain documents and we have contested. And thereafter, that particular, the appeal is allowed, against which I preferred the writ petition before this honorable court. When the matter was pending before the learned single judge, that register was produced before the court to know that whether I have been granted after the remand, that it was produced and thereafter that the order was passed. Therefore, on the last occasion, I made my submission. You secure that record because after remand, it is not available here. That on the last occasion, we have verified, my learned friend and myself have verified that that register is required.
Is that so?
without prejudice, notes, the list says only with regard to 15 guntas.
Correct.
Notes, it is like this. The appellants.
This is not with regard to 15 guntas. This is with regard to 1 acre 5 guntas.
Why?
No, lords. It is only with regard to because I was allotted 15 guntas, the second appellant 15 guntas, and the fourth appellant 15. Not she has to make out as to how she got that 1 acre 15 guntas because there is no excess land. Not apart from the land, it is not our case that there was a land that I'm in possession. The question is Annexure A may kindly be seen. Notes Annexure A
Is it your case if
that
she is
both of our yes.
if she is granted the 1 acre 5
15 guntas,
you are-
we
you
will
are
lose
com-
our land. That is our case.
Correct.
This is the only list notes. So she cannot be granted under any stretch of imagination 1 acre 5 guntas without we being heard. That annexes notes B to J which have been produced and which he is notes relying upon or passed behind our back. And we were not.
Therefore, this 1 acre 5 guntas which he says he is entitled to will encompass your land also.
Yes.
So that is his
That
his
is
case,
the only
Lord.
crux of the matter.
Total extent
Otherwise,
my
otherwise
learned-
there is no land.
My learned friend's contention is it is 13 acres.
Correct.
He himself has produced his total extent is 24 acres. So therefore that I will demonstrate. So if I am not entitled, then the court will pass.
As a matter of fact, it
Yes.
encompasses their land. They have also.
No,
a grant.
I am not, they are also having 15 guntas. I am not claiming the 15 guntas in their land.
Not in their land.
Yes,
you
my
may-
lord.
If our
Yes.
land is granted plots, we are very happy with that plots. She can take whatever she want. We are entitled for 15 into 2, 13 tons
That's
of
all.
land. That's
That
all
is all.
plots.
Yes.
We are happy with that.
If it does not encroach into your
Yes,
land, you have no
yes,
complaint.
yes,
I
exactly.
was wondering what exactly your problem is.
This was the crux plots.
It is only now that I understand.
And plots, the funniest thing is the Tahsildar issues Form 7 in favor of all the three, but he does not sign it. Everything is ready. Everything is kept in the file. For 15 guntas each, he does not put his signature. Subsequent to the order at team lots, my name is mutated in respect of 15 guntas and we have been issued with Form 7. Now, lots, if this writ petition is allowed, all our orders will go back.
But I presently have the records of form number 50 being filed for the first time by each of these petition appellants and the respondents. Those
That-
records are available.
That was in respect to 15 guntas only? Only 15 guntas?
Yes.
How did this 1 acre 5
5
guntas
guntas
come about is the
I also
question.
went through the entire records, Manoj. Suddenly documents are there to show 1 acre 5 guntas. So I will also verify, take.
Please
inspections
verify.
from
How
the
that came
department.
about is the question.
What is actually happening? I shall take inspection.
Highly obliged.
Learned government advocate seeks further time to verify the records received as also to get records with regard to the enhancement of the land granted to the
Fourth respondent,
to the fourth respondent as 1 acre 5 guntas.
5 guntas. Highly obliged.
List after 2 weeks,
Please.
2 weeks,
3 weeks.
3 weeks only, Manoj, because I have to get.
Yes, you have
the
to
old
get
records.
this, you also have to look into those and tell us how. this-
Kindly fix a date, notes.
18th.
18th. Much obliged.
18th of September.
18th September.
Obliged.
Pen go. Let's see. What about the, there is no part B? No part B. Can we raise, I can, finish one. Yes. Then I can finish one dictation. Only one to the very.
our society. When entities with deep pockets get in, my lords, their interest will be monetary interest and not necessarily to preserve the lake. In the garb, the BBMP may well say, we are giving you the possession to make a road, to make a park, to make benches, to make the Senior is leaving to their two heads. Right? That was like a good time for us to leave. No, actually, my matter just gets done by 2 hours. I'll go home. Mom's got a fever again, it seems. That this fever is not as high as she's getting my 99, 100.
Kindly. I'm aware that, my lords, I should not take adjournment in when the matter is listed on orders list. But I have intimated the other side. Seal number 26 in the 28 at first list, my lords. It requires hearing. University has engaged the senior counsel in the matter. He is not well. That is the reason I am requesting for next week. I have intimated the other side also.
Lords, I appear for the respondent. I just pray for a date, my lords.
Adjournment.
What was the office objection there?
Office objection, respondent has to file a synopsis.
That is all.
Matter was taken up for hearing, my lords, on the previous occasion. So in the next week,
We can have it in the next week?
Grateful.
I only request for a date, my lords.
Yes.
Grateful.
Pronouncement of judgment,
Grateful.
230, number 51.
Waiting for the
Aniket,
respondent, ma'am.
Yeah, please.
Appeal is dismissed as not maintainable. It is made clear that the appellant is at liberty to work out his remedy in a legal and proper manner.
$52, Prithvish MK.
If petition is allowed, the order of the tribunal is set aside. The Government order dated 19/5/23 shall also stand set aside. This will not stand in the way of the competent authority initiating action in accordance with law if the same is permissible in law.
Orders, 2:30 PM. Number 23.
For the appellant, my lord, second set is filed. Both sets are filed. The appeal has been admitted in the year 2017 itself. Could it be taken up for hearing sometime?
Synopsis filed. Yes, everything is in order.
Everything is completed, my lord. Your lordship may fix a date for hearing.
What is the IA for permission?
Lord, A could be
IA.
heard along with the main.
Yes. List for,
A date may kindly be. fixed.
yes.
Second,
Please, oblige.
24, Chandranath Tariga.
My lord, appear for the appellant. It is understood that the matter is to be heard today. I am ready.
Pass over.
Please. Office objection has been complied with.
Yes.
25,
Or accommodation to file my synopsis and your lordship.
Become infractious.
Infectious agala. Because your lordship, on the other day, I submitted before the other coordinate bench, your lordship. It does not become infectious for the reason, your lordship. A stage carriage operation permit was granted, your lordship. And various grounds have challenged your lordship. The scheme is existing and when there is a pendency of the scheme, your lordship, the petition respondents are not entitled for grant the permits.
It's a total exclusion scheme.
So yeah, at that point of time, it's a total exclusion team, your lordship. So I made in the meanwhile, the renewal has been granted. That renewal I have challenged, your lordship. And another single judge has been rejected it, your lordship, and I filed this present writ petition. In the meanwhile, another renewal has been taken place.
Therefore,
Maybe-
the period of the renewed.
Renewal is but very.
2013, the period
But very
is over.
object, very object.
Subsequent renewal is also granted.
But very object, your lordship, the first instance, your lordship, the granting the very permit itself bad, your lordship. That has to be ascertained, your lordship, because the very, it keeps on, for every movement, your lordship, I file the writ petition. It by the time, your lordship, the renewal takes place. And the very grant.
Depend on what is challenged, counsel. If what is challenged is only that particular renewal.
No,
then
entire.
What is the challenge?
Stand, your lordship, is the entire renewal, your lordship. That is the order passed by the.
If the renewal is all that is under challenge, How can we go behind that?
No, no,
and
not,
consider
not
the
only renewal, your lordship.
grant?
The very grant I have challenged.
What was the challenge? Please tell us. what
Only
the
renewal,
challenge is.
not original grant.
Because what happens, your lordship, the original grant, your lordship, it is going to unagitated, agitated.
Question, what was the prayer? If it was only renewal that was challenged, then we cannot consider the challenge against the original grant.
In fact, matter is covered by a division bench judgment. I have produced along with my AF for additional documents.
It is renewal. In this question, your lordship, it's renewal is there.
What is under challenge?
Because your lordship, the total, this, not a single judge has passed the order, your lordship, renewing the permit,
Therefore,
with the liberty to renew the permit.
what was the prayer? What was the subject matter of the challenge before the?
Subject matter, we have challenged your lordship at,
Please. Is the scheme still in operation?
there are various schemes are existing, your lordship.
Is the
Various
scheme-
schemes are existing.
Is the scheme still in operation, the scheme that you?
Yes, yes. Now, your lordship, a comprehensive area scheme has been issued now, of late.
And permit is saved.
Existing permits are saved.
Existing permits are saved, your lordship.
All permits granted issued, which were in operation as on 18/12/2014 are saved.
I'll make out, your lordship, the case, your lordship, because
When
today,
was the grant? When was the grant?
grant, your lordship, 93, 94, original grant.
No challenge.
We have challenged, your lordship.
Where is the challenge?
93, 90, it was kept on, your lordship, because there are various other histories. That's why, lordship, this court wanted to furnish all the schemes and the previous judgments of this court as well as the apex court. That's why, lordship, it was said, your lordship, and I'll produce that all the 21 schemes. And
Initially, permit was granted from the year 1993 for various.
Yes,
periods
yes.
Up to 16/8/2008.
by the time,
Renewed from time to time.
yes,
Latest renewal was from 17/8/2013 to 16/8/2018. Therefore, the subject matter of the writ petition was the renewal.
No, by the
from
time-
2008.
by the time, your lordship, may I submit, your lordship, by the time, your lordship, various repeat, your lordship, during the history is like this, your lordship, during pendency of the scheme, your lordship, the authority has issued various permits, your lordship, in violation of the schemes. The subject matter, your lordship, went up to the Supreme Court. Then Supreme Court, your lordship, Adarsh Travels case as well as Ashrafullah Khan case from Karnataka, it's referred back to the Honorable Government of Karnataka to redo the scheme, whether it has been saved or not, your lordship. Then, your lordship, this government passed another notification, withdrawing all the permits notifications which has saved the permits which are granted violation. 5/8/2015, one notification issued by the government withdrawing all the permits which are saved. Then, your lordship, that has been challenged by the operators again. Then, your lordship, this matter again has been to the government. Then 2000, then, your lordship, another matter was
2017,
17.
there was a further notification.
Yes.
It said that all permit holders who were operating as on 14/1.
28/9/2017.
Exempted, yes.
Exempt, 28/9/2017.
Yes.
Then, your lordship, that notification has been, your now lordship, that has been challenged by the operators. Now, in fact, your lordship, that notification has been now affirmed by the learned single judge. In the meanwhile, lordship, another notification was issued, 7/3/2019 7/3/2019 notification. A comprehensive area scheme, your lordship. There also it is, your lordship, there, no doubt, according to them, your lordship, it is saved.
Correct.
But my submission, your lordship, from the date of the very inception of the permit, your lordship, that is as a 1923, your lordship. The said permit was in violation of the original scheme.
That was not the subject matter of this writ petition at all. What is the point in us considering a writ petition? I mean, writ appeal, where the subject matter is only the renewal from 2018 to 2022.
Yes.
That is all that is under challenge. That is sought. Now that has happened. Now, if your contention is that there is some other notification by which it is not saved, That is to be urged in separate proceedings, not here.
No, I'll convince your lordship, the next date I'll convince your lordship. I'll convince your lordship on that point.
Does not appear to be any convincing to do, counsel, because this was the only
No, no,
issue
because-
was with regard to the
No, see, your
renewal
lordship,
from 2018.
by virtue of all this happening, your lordship now, totally the corporations are tired of operating the services to the stage we have reached now.
That is not the issue.
Not the
That
issue.
will
I'm
have to be
just-
considered in separate proceedings.
I'll point out your lordship and I can,
Or if you are seeking to challenge, you as a corporation are seeking to challenge any provision in the notification, you have to challenge it. It is open for you as the corporation, even to challenge an exclusion clause in the notification. You can. You are the beneficiary of the notification.
yes.
If there is a provision in the notification which goes against you, you're free to challenge it. But then without so challenging, how
No,
this is only with regard to one renewal. How can it be?
Subsequently, the permit has been renewed in 2023.
That is what.
That has
No,
to be
that-
challenged.
No, that is why your lordship.
Now present application is
Why-
for 23 to
Rather,
28.
rather than your
Pending
lordship,
Before the RT.
rather than your lordship, ultimately what I submit your lordship, rather than this private operator operating service with the valid permit, they kept on operating the service with the permission of the court by obtaining the interim order. By obtaining the interim order, their renewal permits are got renewed. By the time the petition which I have filed, your lordship becomes infectious. It goes on continuing.
Yes,
Next day to your lordship.
yes. At the request of the learned counsel for the appellant. List after 2 weeks. All the office objections shall be complied with by then.
Well, please, your lordship.
Public.
26, Sundararaman.
My lord, appear for the petitioner's counsel. My lord, on the last occasion, a memo was filed, memo of calculation was filed by the other side. My lord, the background to it is this. My lord, during the pending arbitration of this proceeding, my lord, it was realized that without acquisition, they had constructed a road upon my premises. My lord, by an order of this honorable court, my lord, we had a joint survey. And based on that, my lord, as far as the road portion was concerned, some compensation was to be paid. Now, my lord, in the process of that survey, it was also discovered about 24 guntas of our land had been encroached and allotted by KIDB to somebody else without any acquisition proceedings. Now, my lord, in respect of that, my lord, we have said that we have no objection. They can give us, compensate us for that 24 guntas of land also. My lord, they have issued the preliminary notification and the final notification in respect of that. Now, my lord, on last occasion, they filed a memo of calculation. My lord, I have only one thing to say. There's no issue even with regard to the memo of calculation on facts. The only question is about computation. If my lord kindly takes that memo for a minute, the memo that was filed on the last date of hearing. There is a notification which is enclosed to the memo. Sorry, a computation, my lord.
Yes.
If my lord turns to the second page, my lord will get the computation. Unfortunately, it's in Kannada. But I request my lord only to kindly go to page number 4 for a minute.
Yes.
Now, my lord, in page number 4, my lord, they have given the values, the guideline values. Now, my lord, the guideline value, my lord, will see at the item number 3. As on date, my lord, the guideline value is 1 crore 50 lakhs per acre. This is the guideline value. Now, if my lord kindly goes to page number 6, I'm sorry, page number, yes, my lord, page number 6, my lord will see in their computation, now this is a computation under the schedule to the Right to Fair Compensation Act. What the value they take is 1 crore 2375,200. They ought to be taking 1 crore 50, which is the guideline value. The explanation by the department is that they say based on average values, we have determined 1 crore 23. Now, my lord, my submission to this is simple. If my lord kindly looks at section 26 of the Right to Fair Compensation Act.
Right to fair compensation. New land acquisition. Yes.
Section 26, my lord.
Hmm.
Determination of market value.
Yes.
No, I have. Section 26, the collector shall adopt the following criteria in assessing and determining the market value of land. Namely, A, market value, if any, specified in the Indian Stamp Act for the registration of sale deeds or agreements to sell, as the case may be in the area where the land is situated. That's the guideline value under Section 45 of the Karnataka Stamp Act. Then B, the average sale price or similar type of land situated in the nearest village or nearest vicinity. Now they say this is 1 crore 23. But according to them, market value is 1 crore 50. Now, my lord, may kindly see the last one. It ends, my lord, whichever is higher. So, my lord,
Consent to the,
the consent amount of compensation is agreed upon the subsection 2 of section 2 in case of acquisition for land for private companies or for public-private partnership project, whichever is higher. So, my lord, A, B, or C, whichever is the higher has to be taken for the computation of market value. Guideline value here is higher than their average value. So that needs to be taken. My lord, if this small issue is sorted out, my lord, then we can receive that compensation and we can
not get the instruction because only today they told us earlier we would have. I'll try and not get.
Actually, we've served we've served a copy of objections. Unfortunately, my lord, because the matter was coming up today, we didn't file it. We have kept it ready.
I'm not complaining about anybody.
Copy has been served to them.
They've given the copy. I'll just
Learned-
not assert it and then come back to you.
Learned Senior Counsel appearing for the respondencies to get instructions. List, when would you want it listed?
Not next week. Next week, I think we should be able to objection. Sort out the issue.
Is there time next week?
Whatever.
4/9.
4/9, please. Now, may permit me to file that objections in the register.
Please.
Wait.
27, government advocates.
That's right. Here for the private respondents, not in this, it's the state's appeal. Not compliance has to be made. There was an-
Deletion of R5, R7, R9.
Please, my lord, we filed an application seeking deletion of those respondents, since, my lord, those are our predecessors in title.
But
And
there are office objections raised on that.
Office objections were not raised on furnishing translations of Kannada documents with that application.
Only that.
That is the only objection, my lord.
Yes.
And my lord, there is already an order on that application saying that for the moment, there is no need to issue notice. That IA has not been formally disposed of, my lord, which is why I believe that objection.
May be disposed of. Yes. The office objections on IA number 1 of 2021 are overruled for the time being. The IA is allowed. Then
Then, my lord,
you want to get instructions in the matter?
I shall, my lord.
R5, R7, R9 are deleted from the party.
I shall
right?
take
At the
instructions.
risk of the. Yes, the amended cost title shall be made available. List after 2 weeks.
my lords, may I please request for the coming Monday, my lord? The urgency is this, my lord. My lord, the only issue, my lord, is whether is the state's challenge, my lord, to their own auction conducted in the year 1940. 1939 and 40, the auction takes place. In 2005, my lord, the Tehsildar says that the auction was wrongly conducted. And they claim for the first time that the land was originally a tank
Auction
bed.
under what provision?
My lord, under the Mysore Land Revenue Code of 1888. Under which, my lord, my respectful submission is that tank beds could have been auctioned, subject to the tank having dried up for more than one season and an assessment having taken place. When the matter was before the learned single judge, my lord, we produced all the documents, including letters of, my lord, vintage 1910 to 1930, showing that efforts were made to revive that tank. The tank could not be revived. There is an order, my lord, of the chief commissioner directing it to be auctioned, as was the procedure under the extant code then, my lord. Then the auction takes place. Then, my lord, the owner at that time, my lord, he sells the property. It's changed multiple hands. Now, my lord, from 1940 to 2005, my lord, once we purchased the property, once, my lord, we have consolidated, my lord, all the appellants, they're holding over the property. Then, my lord, the Tehsildar says that, oh, in 1939, it was wrongly auctioned. So there is, my lord, the one question is, my lord, limitation, whether they could even venture into doing this. The second is, my lord, the second, my lord, is the legal issue. There is no dispute really, my lord, on facts. It's a legal issue. Whether, my lord, under the extant Land Revenue Code of 1888, a tank bed could have been auctioned. And, my lord, the answer in my respectful submission is contained in Rule 16 itself, where the rules, my lord, provide for different situations. When the tank bed has dried up for only one season, what is to be done? When it is dried up for more than one season, what is to be done? And, my lord, all that procedure is followed. The Honorable Single Judge has considered all of this, my lord, and interpreted and, my lord, considered the documents of 75 years ago and passed a judgment whereby, my lord, the order of the special deputy commissioner
holding that our names ought to be restored as the khatedars of the property, that order was upheld by the learned single judge. Now, my lord, state is in appeal. My lord, I have been deprived, my lord, of my name and the revenue records from the year 2005, when the Tehsildar, my lord, begins this misadventure. It is almost 20 years, my lord. I'm not able to use the property. I'm not able to, my lord, undertake any construction or, my lord, seek conversion, my lord, to be used for either residential or other purposes. And that's the only urgency, my lord. It's a short issue. Synopsis is also filed.
My lord, the learned additional advocate general would be appearing in this matter, my lord. May kindly be called in the week commencing from 17th September, my lord. Or 9th September, Mondays also. I shall take instructions, my lord.
Yes, please get instructions. and,
Please, 9th, my lord.
Wait. This final hearing, we won't hear. It will not reach. So we'll have it on 9th.
9th.
9.
Yes.
Grateful.
27 at 28 urgent, 29 PB Shukumar.
The shifting of the transformer.
Yes.
But I would say that not this transformer which is being put is just abutting to the property of the appellant. Now, I asked for a shifting at my cost. I'll pay the amount and then I shift the cost. But if they consider that shifting can be done at my cost, I'll pay the cost. I have also showed a sketch where the shifting can be done also. But it's no man's land where I have notified it saying that in that place it can be shifted.
What do you say?
In the first instance, Lord, as instant of the first appellant, Lord, that got it shifted to the present state. Lord, that in the present after installing, that you want to shift it somewhere else. Lord, that is only in his cost, he has to got it under self-execution, Lord, that it is his own risk. Lord, that his application is submitted, that will be considered in accordance with it.
Lord, let it be considered. Of course, Lord, I'll pay the amount and get it shifted. I've almost completed the house. But some untowardness may take place, Lord. That is the difficulty. It's a electrical
Be
transformer.
considered in accordance with law, within a time frame we can
Yes.
direct.
But,
This can be done.
my representation, if considered, that may also to be noticed, that shifting can also be considered by them.
Shifting also can be considered under the self-execution, he knows in his risk.
Self-execution at my cost, I
Yes.
see that it is. That was what my
Self-execution,
previous-
Lord, that appointing the class 1 contractor, Lord, we will inspect, we'll feasibility report, we'll estimate, we'll intimate them.
Let it be estimate, we'll pay the amount and get it shifted.
That is, Lord, that annex page 159, that representation which has been given, that has to be considered in accordance with.
The petition, appeal itself can be disposed of on those lines, or do you want it?
Let them consider and place it before the court. Within a week, Lord, I'll pay the amount and get it shifted.
That we have to estimate, we have to get it approval from the higher officer.
Let them give the estimate also.
It took 3 weeks time.
The learned counsel for the appellant submits that a representation has been submitted by the appellant seeking shifting of the transformer at his cost and risk. And what is the term you use?
That under self-execution scheme.
Self-execution scheme.
Self-execution scheme. The learned counsel appearing for the respondent submits that the said representation will be considered and appropriate action taken within a period of 3 weeks. The said submission is recorded. The representation shall be considered in accordance with law, list after 3 weeks.
Much.
So if it, as a matter of fact, it is done.
Yes,
Then we can,
Estimate may be given to us. Lord, so
That
we can report.
estimate, that after inspecting, you prepare estimate and we get the approval higher officer, then we'll intimate to them. That is the process.
Please.
30, Kiran BS.
My lords, I appear in this matter for the appellant. My lords, it has come for not filing of the written submissions and citations. My lords, I believe we have filed it today itself, this morning. And so it can be fixed on any date that is suitable for everybody. We can do the arguments. From our side, we have just filed it today.
But so far as R6 is concerned, it is ready. We'll either file it here or in the registry subject to your lordships.
Prince.
And if we can fix a date, my lords, for hearing which is convenient to it. Would 6th February, if it is convenient. 5th or 6th, 5th or 6th September, I'm sorry, September. Sorry, my lords.
6th appears to be. Yes, it
6th is a Friday, 5th or 6th, what?
6th is appears to be a holiday for us.
5th, my lords, or 9th, not 9th, 5th, my lords. 5th
5th
also.
or 10th? 5th.
We'll take our chance.
5th,
Yes.
grateful, my lords, grateful.
31. Hegde Sundamade.
I prepare for respondent number 1. My lord. Respondent 1 is a bank. They have able to obtain interim audit proceedings under Surface Act. Not complied with the office objections. The interim order granted subject to compliance of the office objection. But there is some, there are 2 lines granted in the interim order 55202. Issue emergent notice subject to compliance of office objection. They have not completed office objection. Notice not issued. I somehow able to get certified copies and file the state IA for vacating interim order. Next, my lord, stay of the disposition subject to each of the petitioners, appellants, depositing sum of 1 lakh only in the registry of this court. Some of them have deposited, some of them not deposited. As such, this interim order may be clarified because there are 2 crore 42 lakhs of rupees is pending due. Here are the tenants, they have to approach debtor recovery tribunal under section 17(4) of the Security Surface Act. Anyway, this one got
You are appearing for the respondent.
respondent 1. Respondent 2,
Petitioner.
respondent, other respondents are the owners. They won't participate in the proceedings because they are the borrowers. I have to recover the amount. The security is not sufficient at this time because value interest is growing, but growing and growing. That's why that interim order may clarified. I may primarily proceed with. But anyway, they got the remedy before a DRT. They may approach the DRT. If they are the statutory tenants as per the law, they will be protected for their time, for the period. That is also over. Their term lease period is also over.
Who has deposited the amount?
This appellants.
Which one?
Appellant number. I think last appellant is not deposited amount.
Only one is not deposited.
On
The others have.
yeah, please, madam. As per the office note, it is like that, madam.
Yes, is there appearance for the appellants? Anybody appearing? Writ appeal 412 of 2022.
Sumana Hegde.
ಇಲ್ಲ ಸುಮನ ಹೆಗ್ಡೆ ಇಲ್ಲ ಸರ್.
Illa. Madam, so far the process also not issued for the last 2 years.
Submitted by the Learned Council appearing for the respondent that though the interim order was conditional on the appellants rectifying the office objections, many of the office objections have still not been made. It is further submitted that in respect of the 7th appellant, the payment of the amount of rupees 1 lakh in the registry, which was the condition for stay of dispossession, has also not been complied with. Today, there is no appearance for the appellants. List tomorrow.
Process also not issued, my lord, because of non-compliance.
Yes.
Please, at 2:30.
32 and 33, my lord. This is, my lord, recalling the order
which is, my lord, dismissed for default by the registry, that is 8/11/2000. Continuation delay application has not been filed. Now I am filing in both cases, my lord.
It is submitted that an
my
application
lord,
for continuation of delay is being filed.
Yes, yes, my lord.
Does we file before registry?
No, now I am filing.
Yes.
My respect. This is, my lord, I've filed affidavit with the application for recalling, my lord, within week, my lord,
What is the time? What is the delay?
delay, my lord, because what happened, my lord, one of the junior colleague, my lord, Keshav, he has, my lord, handling the, my lord, cases, and suddenly he has left to his parents' house because
What is the extent of the delay?
629 days.
Copies are not
Oh.
served on the state, my lord.
Please serve a
Writ
copy.
appeal copies, IA copies.
I'll
none are
serve, my
served.
lord, insofar as, my lord, rectification, my lord, I'll rectify it.
Registry and file medicine.
Because
Please.
the time also has to be verified.
Yes.
And copies have to be served also.
Please.
Please
Have
file
any
it
date?
in the registry. List after a week.
Date may be fixed. Date. In the meanwhile, office objection also will be completed.
Yes,
That may be.
this is the office objection. Please file it before the registry. Then there'll be no office objection.
Please.
Yes. After a week.
34, Shivram Bhatt.
Ma'am, ಯಾವತ್ತು ಕೊಟ್ರಿ?
On behalf of the applicant.
ಯಾವತ್ತು ಕೊಟ್ರಿ?
Non-filing chart of computation of salary.
For 2 weeks. Please.
Yes, 2 weeks time sought for granted as well. There is a filing delay as well. Continuation of delay, application of application. That also, if you have objections, please file it by then.
35, government advocate.
My lord, I pray for 2 weeks' time. my lord. Pray for 2 weeks' time, my lord. I have to take out steps. There is, I have to take out steps for respondent number 45, my lord, and process to the other respondents. I pray for 2 weeks' time, my lord.
Have some urgency, my lord, or promotional avenues are, my lord.
Weeks time sought for by the learned government advocate.
I have to take steps, my
after
lord.
2
For
weeks,
that
please-
reason, 2 weeks.
please
Obliged.
May I request?
Do
my
the
lord-
necessary at the earliest. Yes.
May I request, my lords, to kindly fix a date after 2 weeks, my lords.
Third,
Grateful.
My lord,
36,
Third may be a
Sharanayas.
short, because I have to take steps and bring the LRs on a.
For filing the, I mean, for taking steps, 2 weeks is not required. Do it immediately.
Third, my lord.
Yes,
Lords, 36, I am appearing for the appellant, my lords.
yes.
For the
It's a very short issue, my lords. The
matter will have to be
appellants,
heard, fine.
my lords,
This is
I
the
will
September-
I will conclude in 5 minutes. There is a reason why the election
Just
commission
a
is
moment,
making
just
this request.
What are the office objections?
That's on main, my lord, they were supposed to comply. This has been lying over for quite a few days now.
Our objections are not there, my lords. It's only on the production of documents on 15/12/23.
Translation copies have not been.
Lords, those were the documents produced to show.
Translations are required.
Lords, whatever is produced along with that memo, I'm not relying upon those documents because that was produced to show, my lords, that there were earlier orders which was passed.
What is the subject matter?
Lords, it's a very short issue, my lords. The appellants are the disqualified elected councillors of Arsikere Town Municipal Council. The allegation was made saying that they had tendered their resignations voluntarily to the party. They filed their objections denying that they have submitted any such resignations. Relied upon the communications interse between the deputy commissioner and the then party president saying that no such resignation has been tendered. The deputy,
Moment, are the translations of those documents?
yes, those documents are available. That is in English. The
So far as
deputy
we are
commissioner,
concerned, we have not.
the deputy commissioner,
Required translation.
My lords, I don't require, but if he is referring to, my lords,
Correct.
why I am telling this
it
is.
sees for the election
If we-
commission, my lords.
Election commission, I am appearing. If your lordship sees the dates, the order sheet only requires, shows only their dates being taken by them.
No,
Today,
we have-
the urgency,
How's
in 5 minutes, this is not a matter which will get over. That much.
But I'll just say this, my lords. I have,
Can be listed on a great date.
lords, the difficulty is this, my lords. The reason why the election commission is making this submission is the elections for the post of president of this municipality is scheduled on 22nd. Lords, no, lords, may I just, lords, may I just,
Yes.
lords, I'll just take 1 minute of your lordship's time, my lords. the deputy commissioner, without holding an inquiry, has held that the disqualification is coming to effect and therefore we are disqualifying him. It's an admitted fact that there is no inquiry conducted. Lords, the division bench or a coordinate bench of this honorable court has held that in the manner of disqualification which is contemplated under the local authorities rules, it is quasi-criminal in nature, and what is the nature of inquiry to be conducted has already been spelled out by a coordinate bench. Those principles are not followed. Matter requires a remand before the deputy commissioner because the learned single judge also proceeds on the ground that there was no denial of tendering the resignation, whereas the statement of objections filed before the authority and also as extracted minutes by the authority passing the order of disqualification clearly reflects that we have refuted all the contentions and asserted we have not tendered our resignations. So matter was required to be dealt with minutes by means of an inquiry. This is the short point and it is covered by 2 coordinate bench judgments of this honorable court. That is all the point. Minutes may just.
But disqualification is on 18/11/21.
18/11/21.
We have the benefit
The
of.
writ petition was dismissed on 21/7/22.
20?
21/7/2022.
Hmm.
Lords, with a delay, they filed the writ appeal, by which time actually the election commission had issued the calendar of events.
Hmm.
This honorable court has only stayed the calendar of events. The disqualification order from the date of dismissal of writ petition has not been stayed.
Hmm.
So, my lord, this matter will only have to be heard on merits. Though we had been pressing all the while, all these days, for taking up the writ appeal. Now, because of a president and vice president election or the reservation being notified, that can't be a ground, my lords.
If
for
they
a
were
matter-
pressing on the previous hearing dates, I don't know why they should not press it even for today. My lords, this is all my argument.
That is a
I will not argue anything further. And election commission is concerned.
We'll consider it tomorrow.
My lords,
Please, my lords,
Consider it tomorrow on merits.
please.
Even pass over and consider it today if there is time.
Please.
That's,
Please.
because so far as the election commission is concerned, we will not be justifying the order. It's passed by the state. We have taken one step in notifying the election of the disqualified
Are you ready?
councillors.
Yeah, ready. Any day tomorrow. Okay. Day after. Day after. Day after tomorrow.
Lordships.
Anything that you're relying on, please have.
Lords,
the
I'll
transcript.
serve an advance copy with a short synopsis, my lords, on it.
Yes. Available.
I'll just
If you're
exchange
relying on
it.
it, please make.
Please,
it.
I shall do that.
Yes.
37. Shashank,
Yes.
yes.
My lord, I'm appearing for the appellant in this case, my lord. My lord, this case pertains to a gift deed which is purportedly executed by the appellant in favor of his second daughter, my lords. Was the challenge before the assistant commissioner, my lords. Assistant commissioner allowed the petition made by the appellant herein. Thereafter, the daughter filed a writ petition against the appellant herein, but the writ petition came to be allowed, my lords, by the honorable single judge of this honorable
Writ
court.
petition stating what? Seeking?
My lords, writ petition.
Challenging the order under Senior Citizens Act has been allowed.
Oh,
Senior citizen. Please.
yes.
Writ petition came to be allowed by the honorable single judge, my lords. Therefore, we are before this
On the
honorable.
ground that the giftee did not contain.
In a condition, express condition, my lords. My lords, herein, there are 2 bones of contention, my lord. First of all, the petition before the assistant commissioner, my lords, it was filed in the year 1617, my lords, the 1617.
Hmm.
The honorable single judge, my lords, has referred to a judgment, my lords, of the coordinate bench of this honorable court, which was passed on 15/10/2019. My respectful submission, my lords, is that until 2019 and until recently, the Senior Citizens Act being a welfare legislation, Section 23 was given a broad interpretation. Therefore, even though there is no express condition in the gift deed saying that the daughter will take care of the father, despite the lack of express condition, there were conflicting judgments of various high courts across the country, my lords, which gave a broad interpretation and said that even if the condition is not there, still the assistant commissioner can go ahead and cancel if the grounds stated in the section 23 are made out, my lords.
What are the grounds?
Thereafter,
What are the grounds stated in section 23 would be
my
relevant?
lords.
Now, where is the appellant now with the elder daughter?
Please, my lords.
Because there are four daughters, my lords. This property was purchased by the second daughter itself in the name of a father, which she gifted. Because
Okay.
during the pendency of the writ petition and subsequently, this daughter is depositing rupees 10,000 every month before this honorable court and before the assistant commissioner as per the orders. This amount, my lords, has now culminated into nearly 7 to 8 lakhs, which has not been withdrawn by the father. Father himself had made a statement before this honorable court that I don't want any maintenance. And till today, we are depositing it.
Therefore, it is not a case, according to you, not a case of lack of maintenance by the daughter. Where any citizen, senior citizen who after the commencement of this act is transferred by way of gift or otherwise his property, subject to the condition that the transfer shall provide the basic amenities and basic physical needs of the transferor.
Well, that point is
And
where
such transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud or coercion or under undue influence and shall be, at the option of the transfer, be declared void.
My lord,
This is the provision of law.
please, my lords.
Hmm.
This provision, my lords, was
and that
broadly
is squarely
interpreted.
covered by the judgment of apex court.
Please, my lords. The law came to be settled, my lords, subsequent to the filing of the petition before the assistant commissioner.
Law is settled, council, this law is settled from,
My lords, we would have approached.
settled from that date.
Please, my lords, it has a retrospective effect.
It's a declaration of law.
Please, my lords, but my respectful submission is that, my lord, we would have approached the honorable civil court and we would have sought for a cancellation of the said gift deed under the provisions of the civil procedure code read with the specific relief act, my lords. That liberty may be granted to us, my lord, to approach the civil court, my lords, at this point in time. Because the law came to be declared subsequent to the filing of the petition before the assistant commissioner. That's the only liberty which we seek before this honorable court, my lord. And the second aspect, my lord, the second aspect is the subject matter of the gift deed. That property is a subject matter of a civil suit, which is filed by the first respondent herein, the daughter herself. She has filed a civil suit for party before the Hoskote Senior Civil Judge Court, my lord. There, the very same property is a suit schedule property.
I have not made it as a party. The father himself has implemented this property as a counter in a counterclaim in the suit. I have not made this property as a party to the proceedings.
Here also, my respectful submission is that another daughter of the appellant herein has made that property as a subject matter of that suit, my lord.
Appears to be a property dispute between siblings rather than by the senior citizen as against the.
Plus, the conduct of the father may also be seen. There's a deposit of nearly 8 lakhs, which I have deposited way from 2021, which has not been withdrawn by the father till today. And the intention is very clear. It is not the maintenance, none of it. It is the other daughters who are
That
instigating the father to claim this.
property disputes cannot be styled in
In
the
Senior
manner of
Citizen.
Senior Citizens Act. That cannot come under this provision.
We are seeking for a liberty, my lords, to be granted to us to approach the civil
That,
court.
that
and
us
challenge the
itself, that us itself is a problem. Because it is not for the father. It is for the other siblings that you're seeking this liberty. Cannot be counsel.
Because the father has always taken the contention that the gift deed has been executed because of undue influence. And it may amount to fraud. That is the contention even before the assistant commissioner.
What is the recital in the gift deed?
Plus gift deed, my lords could kindly get it at
Translated copies at annexure?
48.
Yes.
That's simple where gift deed which has been given in 2013, my lords. And 4 years thereafter, he files a petition.
I I have gifted away the aforesaid landed property to you by way of executing this gift deed, registered the same in your favor. This is executed on 14/2/2013.
Please.
When was the application made?
2016-17.
20th of
Please tell
December,
us the date.
20th of December 2016, Annexure B, page 30.
30th of
30.
December. 3 years is over even by then. You could not have filed the suit, even if you had filed that suit instead of this application.
That is the reason
Time
why
was-
they come
Time
before.
was gone.
That is the reason.
You cannot urge it. You cannot urge it because your first action in filing this application was time barred.
Therefore, we request for liberty to urge the
What
grounds
liberty?
to approach the civil court of appropriate.
Exactly, you cannot.
If the law permits, if the law gives them the liberty, liberty is always there.
As per
Not-
as per the provisions of law, the liberty may be granted.
The learned counsel for the appellant submits that the authoritative interpretation of the provisions of section 23 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007 has been made by the apex court only in the year
2023,
2020.
in the case of Sudesh Chikkara versus Ramti Devi and others.
And that in the case of Sudesh Sikara versus Ramti Devi and others.
Until there is a condition stipulated in the gift deed, it cannot be satisfied.
It is submitted that the contentions raised in the writ appeal may no longer be relevant in the light of the laying down of the law by the apex court. However, it is submitted that the findings of the learned single judge should not stand in the way of the petitioner, of the appellant urging such contentions in accordance with law in appropriate proceedings if permitted under law. The learned counsel for the respondent submits that the gift deed which is under challenge is a gift deed registered in February 2013, and that the application before the
2012-2016.
authority was made only on 2012-2016. It is submitted that if the petitioner has any remedy in law which is permissible in terms of the facts as stated, he is free to exercise the same. With the said observations, the writ appeal is dismissed. Delay condoned. Delays condoned. Delays, we usually pass an order in the delay.
Because the amount we are depositing before AC as per the orders of land assistant commissioner, which they are not withdrawing it till today.
What do you intend to do about that?
We are not going to withdraw that.
Because then that assistant commissioner
In
could
view
refund
of
it.
the submission made by the learned counsel for the appellant, that the amount deposited by the private respondent herein is not intended to be withdrawn by the appellant. The respondent is free to withdraw the said amount by making proper applications on proper identification.
And
further
the amount for further deposit could be modified. As per the learned single judge, he has directed us to deposit for till his death,
What is the direction? To deposit before this court.
before the assistant commissioner till his death, to the tune of rupees 12,000. If he is not inclined to withdraw any amount, my lords,
Can we say
there's no
so?
purpose would be served for me
The learned
depositing.
counsel for the appellant submits that further deposit in terms of the judgment of the learned single judge
Page 15, my lords.
can be done away with in view of the fact that the appellant does not intend to withdraw the said amount, the said submission, in view of the said submission. The,
Page 15, para 2. A sum of rupees 12,000 is to be set.
the making of the monthly payment is also dispensed, in terms of the order of the learned civil judge is dispensed.
Right.
List. 38. Vilas.
But I filed the synopsis on 14. But it shows that it has not been.
Is available? Synopsis? What is the matter about?
It's about the workmen's union raising a dispute in respect of a workman who was not allowed to work. And then the orders were passed allowing her to work. That was complied with. Again, that was challenged. And once again, application was made that she is being refused work. So again, she made that application was considered and has been granted, but still she is refused to work. And in spite of there being a order of the division bench. So I was directed to file a synopsis.
Synopsis. Only it is filed today. It appears.
I had filed it on 14th and my learned friend, it appears, has
I filed it today, madam.
Can you have it next week or week after next?
Yes.
Verify my decision.
Please, I'll also verify because I have a acknowledgement.
It's not here. Yes,
I had the acknowledgement of having
filed it.
filed.
In the registry. Yes, listed on. List after 2 weeks, please give a date.
4th, 4/9.
I'm ready.
For verification. Consideration of 4/9.
39, Abhishek here.
One and two.
Prayed for an accommodation for him to file the objections which he has not filed.
No, I already filed in 17th, but not put up the thermal court.
No.
ಕೊಟ್ಟಿದ್ದೀನಿ. ಅಲ್ಲ ಕಾಪಿ ಅವ್ರು ಯಾರು ಕೊಟ್ಟಿದ್ರು ಕ್ಲರ್ಗೆ ಕಾಪಿ ಸರ್ವ್ಡ್ already filed an objection to 17/8 but not put up, therefore humble request is kindly direct office to put up the objection to said.
It's here.
But there's an objection filed for the writ appeal, which my learned friend is now relying on, which is now being served. Delay may be condoned and may be posted on
No.
24th for admission, my lord.
80 days of delay.
Please. And I was not made a party before the learned single charge.
No, my lord, the delay is not filed affidavit, not stated, clearly stated delay.
A1 of 2022.
Please, that is with respect to delay of 80 days, wherein I was not made a party before the learned single judge. Hence, have maintained an application for grant of leave also, lords.
What is the application about?
Lords, this entire saga of the brief facts of the matter is, there was a rectification happened by the municipal council of Hoskote. That has happened at my behest. I have filed in representation. The respondent number 1 was issued with a show cause notice. They have also come before the municipal council, files their response. After a detailed consideration, they have rectified. How the respondent behind my back approaches this court and canvasses a matter as if it is a suo motu rectification. They suppress that there is an issuance of show cause notice. They suppress the fact that they have appeared before the council. In the meantime, they also approached regional commissioner. There was a dismissal of the revision petition also. All these material facts are completely suppressed before the learned single judge.
No, my lord, all the
With ulterior
matters
motive
separate,
not
separate
relevant.
aspect. They already challenged before the RP number, before the single judge pending before the another writ petition. I'll already stated in my objection, my lord, the address the argument, therefore humble request is allowable court kindly next week. Address the detailed arguments.
Council, what is the material to show that it was on your application that the rectification happened?
Turn to page number 364 of my writ application.
Yes, it's here. 364 is here. Yes.
This is the translated copy. May I read, my lord? To the legal court?
Please.
Objection application for not issued form number 3. In respect of the above subject, coming in the limits of the Hoskote Municipal Council, now in respect of the City Municipal Council, in the limits of Hoskote City Municipal Council, coming forth layout,
Now to the city municipal assessment number 29602565/89/82. Property in respect of this regard rectified the measurement of our objection there. This is a very bad translation, lots I can see.
It's a terrible translation.
Lots.
Yes.
Therefore, in respect of this property, without our permission, not issuing the form number 3 to anybody, as I am hereby requesting you. This is being issued. My apologies, my lord, it's not.
Can you please read it out to me in Kannada?
Please,
Yes.
right copy is at 363, my apologies, my lords.
Hmm.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೊಸಕೋಟೆ ಪುರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಈ ನಗರಸಭೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೊಸಕೋಟೆ ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಕೋಟೆ ಪಡೆಯ ಮನೆ ಈಗ ನಗರಸಭೆ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ 296025658982 ಸ್ವತ್ತಿನ ಸಂಬಂಧಿಸಿದಂತೆ ಅಳತೆ ತಿದ್ದುಪಡಿ ಆಗಿರುವ ಬಗ್ಗೆ ನಮ್ಮ ತಕರಾರು ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಸ್ವತ್ತಿನ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾರಿಗೂ ಸಹ ನಮ್ಮ ಅನುಮತಿ ಇಲ್ಲದೆ ನಮೂನೆ 3 ಕೊಡಬಾರದಾಗಿ ತಮ್ಮಲ್ಲಿ ಹೇಳಿಕೊಳ್ಳುತ್ತೇನೆ. That is expressly my objection towards whatever the rectification at behind my back is done. Post this, my lord, over the page at 366. This is a show cause notice issued by the municipal council for the very respond number 1. This is to inform you that the municipal account number so and so read in the launch measuring 150 into 120 feet property. That is, the account is in the name of Ms. Gayatri, that is respond number 1. But Mr. H.R. Dharamsingh, who is the appellant before my lords, said that the measurement of 150 into 1 has arrived. Dharamsingh Town has filed a dispute application on 8/6/2015. Thereafter, within 7 days of the receipt of this letter of understanding, the documents are to be submitted to this office along with the original documents regarding the arrival of 150 into 120 feet property for asset. If it is wrong, action will be taken to cancel the. This is a show cause notice. Pursuant to this, notes over the page. At page number 370 is the translated copy. This is the response given by the very respondent number 1 to the council. It says from Ms. Gayatri so and so regarding answer to the intimation letter issued by your office. All these facts have been completely suppressed before the learned single judge.
And what is the finding of the learned single judge?
Learned single judge, because it has been misrepresented that it is the proceedings of suo motu rectification at 18 onwards, Lord. Thank you. Now to start at page number 30.
Yes.
Please. The petitioner claim, may I read the entire order?
Hmm.
The petitioner claims to be the owner of property bearing number so and so, east to west 120 feet, north to south 150 feet, situated at Kote, Hoskote town, Bangalore rural district, having acquired the same by virtue of gift deed dated so and so, executed by his father in pursuance. I will skip the facts, but I will directly go to.
Yes.
Para 2, my lords. Learned counsel appearing for the petitioner submit that the extent has been modified in mutation registered by respondent number 2 without issuing notice, and said rectification is contrary to the registered gift deed so and so. On the other hand, learned counsel appearing for the respondent number 2 submits that the property register has been rectified on the basis of the decree passed in so and so and also actual extent of the land available. Hence, he submits that the rectification over the page. Not the reasoning is at the last fag end of the.
Yes.
However, property register record was rectified by respondent without issuing notice to the petitioner, so as to give an opportunity to petitioners to substantiate his claim that he is the owner of the land and to an extent having acquired the same through the registered gift deed. Hence, the rectification of property modified is in violation of principles of natural justice. Only on this score, this very writ petition. And lordship, it's too well settled in a day that a person who approaches a writ court under 226 when he is guilty of suppression, the matter cannot be heard on merits at all, lords. Hence, this order cannot be.
One more submission, man. This, the appellants already filed a objection to said, respondent 1 and 2 already filed a objection to said municipal authority. Municipality authority details order passed by the details order. The copy already produced before the Honorable Court. And one more document produced before the Honorable Court. I sought for 1 week. Kindly 1 week. Next week, I produce some documents. The said appellant appear before the municipality.
You can consider counsel. In the meanwhile, it appears that he is a necessary party. He has to be heard.
No, my lord,
Appeal
is
has to be
I challenging the only summary order. That is not question of law. That's why I'll address the argument, details argument, some of the documents produced before the Honorable Court, kindly to 3-4 days accommodation. The order passed by the
For
municipality.
this, what do you have to say? That you approached this court stating that it was without notice It was a suo motu revision.
Sumoto
Yes.
order, my lord, they,
Not
the
appealed
respondent
because-
not challenged before not party to the said proceedings. They said appellant not a owner of the suit said property in question.
Why
That's
was he not made a party? Was on his application that the rectification happened.
No, my lord, I produced some documents, therefore, humble
What
request is,
documents do you want to produce? Tell me.
all 3-4 days accommodations.
Please
my lord.
tell us what is the document you want to produce?
No, no, yeah, already it's stored in the municipality office, therefore, humble request is humble kindly 3-4 days accommodations.
Yes, IA number 1 of 2022. This is a IA seeking continuation of delay of 80 days in filing the appeal. IA number 2 of 2022 is an IA seeking grant of leave to file the appeal. Having considered the contentions advanced and in view of the specific averment made by the learned counsel for the applicant in these IAs, that it was on the basis of the objections raised by the applicant that the orders of rectification had been passed by the competent authorities, and in view of the fact that the applicant was not made a party to the writ petition, we are of the opinion that the IA is required to be allowed. IA number 3 of 22 and IA number 1 of 22 are therefore allowed. List the appeal for admission. You can produce whatever you want to produce before that date.
31st. 40, Navi Daman.
Petition is filed by me, Lord, seeking time, Lord, to remove all the fixtures, Lord, from the premises, Lord. Because now, objection is filed today, Lord,
Objection.
portion of the objection, Lord, Lord, I have to verify on my client, Lord.
My lord, it is only fittings. It can be removed within a span of 3 days, within 3 days. Unnecessary, my lord, the application having failed, they have not moved that application. Even they are not coming forward to remove. I have no objection for removal of the fittings. Let him commence the work from today only.
From morning, Lord, I just informed my client, Lord.
He is with me. Let him come today only. Let him come today.
No, Lord. Just now I have spoken to my client, Lord. He will be sharp reporting today at 11 AM, Lord.
My lord, I am not able to give on lease for others. Some persons are coming forward. Because of these reasons, my lord, I am not able to lease it out. I am really.
What time will you require
Lord,
to remove all the
tomorrow, Lord,
fixtures?
tomorrow we'll start removing all the fixtures, Lord.
2 days?
It may
2 days.
become, Lord, I don't know, Lord. It may become, Lord, minimum 3 to 4 days, Lord. I don't know, Lord. Maybe, Lord, I may be given, Lord, at least 4 days time, Lord.
4 days, I have no objection, man.
It is submitted by the learned counsel for the appellant that 4 days time is required to remove the fittings and fixtures. And that vacant possession will be handed over after the,
Possession is already handed over to them, Lord.
and that the said work will be completed within 4 days. The said submission is
From tomorrow.
recorded from tomorrow.
Yes.
Yes. List on,
Three days, Lord. 5th day, let it come on 23rd.
yes, list on 23rd.
Now there is arrears of 2 crores and odd. The matter itself can be
I
closed.
am sorry, Lord. I'm sorry. It is not too close, Lord. 150, it is already in deposit, Lord, that is they had taken.
My lord,
Lord.
I have filed a memo
Lord,
of
I have said no objection filed.
all the rents has been
I
paid
will
either by check or by RTGS.
Lord, they use
Therefore,
55 lakhs, Lord. I will establish. Lord.
Let him produce at least a
I
memo
will
of
give,
calculation.
I will give.
Yes, let's hear it on 23rd.
Yes,
If by the time it is over, then
I will give
That
tomorrow,
can-
Lord, will not
yes.
memo of calculation.
yes,
Lord, if
please.
they are satisfied, Lord, we will close it.
Yes.
Obliged.
41, VB. Prashant VG.
Maintainability.
The maintainability objection has an answer in CPC itself. The question is whether an appeal will lie.
Appeal will lie against, just a moment.
Yes.
Yes.
Kindly see CPC law.
Appeal will lie against,
Against an order passed under 47 of CPC. Can I request Lordship to see 47?
yes, yes. Yes.
47 says questions to be determined by the court executing a decree. All questions arising between the parties to a suit in which the decree was passed or their representatives and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. That's the dictum of 47. Now, very rarely will a situation arise where the executing court will go behind the decree and say that the execution cannot proceed. But in the instant case, the decree in question is not passed by the executing court. It's a foreign decree. And Dubai being UAE being a reciprocating territory, I bring the decree over for execution before the Bangalore Commercial Court. Under 47, the order, he files an application under 47, and an order comes to be passed saying that the decree was not drawn in terms of section 13 of CPC, and therefore the execution is dropped by the executing court. Now kindly see 99 capital A. Kindly first see the scheme of, may I request the court to kindly see the scheme of appeals before going to the orders in the sections itself. If lordships kindly see part 7 from the index of CPC, part 7 deals with appeals. Section 96 to 99A are appeals from original decrees.
Correct.
Thereafter, appeal from appellate decrees. Thereafter, appeal from orders. So in the ordinary course, the order 43 principle arises from 104 and 105. Appeals from orders. But here I am not on section 40, I am not on order 43 appeal. I am on 99A. Can I request lordship's attention to 99A?
Yes.
"99A says, without prejudice to the generality of the provisions of 99, no order under section 47 shall be reversed or substantially varied on account of any error, defect or irregularity in any proceeding relating to such order, unless such error, defect or irregularity has prejudicially affected the decision of the case." Therefore, the stand of the registry that appeal per se is not maintainable from 47 is belied by this. Whether substantively it qualifies 99 is a different question. But if an order is passed under 47, will that be subject to an appeal or a review or a revision or a writ? This itself makes it clear that an appeal lies. Now, of course, for the appeal to be considered qualitatively, I have to show that it can be substantially varied on account of error, defect or irregularity in a proceeding. That's an aspect that lordship will consider on the merits of the...
And whether it is prejudicially affected.
To the case. Here it is prejudicial because the decree is dropped. So therefore, the registry objection, so far as the registry objection as to how an appeal is, commercial appeal is maintainable, the appeal is maintainable thanks to 99A because it's an order passed under 47. And that's the short answer. So therefore, office objection may be overruled. A confusion arises because the situation rarely comes.
Commercial codes. Commercial codes.
Commercial code, lordship will see section 13.
Section 13 would. But the TADA is only
Any person aggrieved by judgment or order of a commercial court at the level of the district judge exercising civil jurisdiction in case may be commercial division court. May appeal with the period of 60 days, provided that an appeal shall lie from such orders passed by a commercial court or a commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure as amended by this Act and Section 37 of the Arbitration and Conciliation Act.
it would be a writ petition.
Lord,
But
Can
the
I-
question is this,
can I trouble lordship?
if it was decided on merit, either dismissal or otherwise, then appeal would have lied. But this is dismissed or as not maintainable. Since it is dismissed as not maintainable, he has to go approach the writ court.
No. Lordship will kindly see. Lordship will kindly see 99A. 99A is the complete answer that for any order passed under 47 will be an appealable order provided On the merits, I satisfy. That's a separate issue, but that's not a registry objection issue.
But the execution petition is dismissed.
That's right.
On that ground, he has to approach the writ court.
No, no, how can appeal be denied? Appeal is the remedy provided by law.
No, if it is an order, does it not have to be an order which is appealable under Order 43?
No, that's why I showed the index. Kindly see the index once again. Kindly see the scheme of the statute. From the scheme of the layout of the provisions,
That
part
may be
7
so.
of part 7.
That may be so, but does not Section 13 specifically say when it is an order that from which an appeal arises?
Lordship.
Then it should be an order which is appealable under Order 43. If it is any other order, does not Section 13 preclude the appeal?
No, Section 13 does not preclude, Lordship.
It does. Not all appealable orders under the CPC are subject to an appeal under Section 13, subject to correction. This appears to be.
Exactly.
Provided that an appeal shall lie from such orders passed by so and so that are specifically enumerated in so and so, as amended by Act and Section 37 of the Commercial Courts Act.
So what we should understand is.
Lordship.
If there is a judgment by a commercial court,
Lordship.
it's appealable.
That's right.
It is appealable.
That's right.
If it is an order, if it is from an order passed by the commercial court or the commercial division,
Lordship.
to be appealable, it must be an order which is appealable under Order 43.
No, Lordship, I'll put it like this.
But that's the short interpretation.
I'll put it like this, Lordship. If CPC needs to be amended by the Commercial Courts Act, the amendment needs to,
Does not have to be.
the amendment provided here,
PC does not have to be amended. The Commercial Courts Act
Lordship.
provides for an appeal
Lordship,
from judgments,
Lordship,
orders of the commercial court
Lordship,
or of the commercial division to the appellate division.
Lordship,
For 13 to be applicable,
Lordship,
judgments are appealable.
Lordship,
For orders to be appealable under
Lordship,
Section 13,
Lordship.
they have to be orders which are appealable under Order 40.
That's the only core issue.
Lordship, I would not, in fact, it is not an order in that sense. That is why I showed the index of CPC. Kindly see, it is treated at par with a decree. Kindly see kindly see the layout of it.
The rejection of
99A falls under appeals from original decrees. Kindly see that. Kindly see part 7 of CPC. 96 to 99A fall under the subsection appeals from original decrees.
Yes.
Lordship has seen that. Appeal
Yes.
from original decrees. So in order under 47, though is not a decree, it has found place within the chapter that deals with appeals from original decrees. Now Lordship will kindly see in that light of the matter, Lordship will kindly see that 99A has not been touched by Commercial Courts Act. Therefore, one is an inclusive approach, the other is an exclusive approach. The Commercial Court Act, insofar as it has not excluded or amended, will apply CPC as it is. Commercial court is only a forum. If Lordship is to hold that it is a writ, then I will file a writ. But this conundrum may be resolved.
If it does not, then is it not a repetition that could be needed?
A separate claim petition. Court does not pass me. It does not survive. The answer is it does not.
Because 13(1)(a) proviso that lordship is on is not an exclusive language. It says, provided that an appeal shall lie from such orders passed by the commercial division or commercial court that are specifically enumerated under Order 43 as amended by this Act and 37 of Arbitration Act. Doesn't say from no other order.
No, it does.
It doesn't, Lordship. Kindly see.
Just a moment. Just. Notwithstanding anything contained in any other law for the time being in force, or letters patent of a high court, no appeal shall lie from any order or decree of a commercial division of or commercial court, otherwise than in accordance with the provisions.
That's
of this
right.
Act.
So Lordship will kindly see 15, 16.
There must be a
16 law.
notification by this court.
The provisions of CPC shall, in their application to any suit in respect of commercial dispute of a specified value, stand amended in the manner as specified in the schedule. So therefore, if the schedule does not amend it, then 99A cannot be excluded by, in an indirect way by implication, Lordship.
Are there any decisions on the point?
No, Lordship, because this question hardly comes.
There are some decisions.
No,
I can make it available.
No, just
Very
as
good,
to,
Lordship.
as
If
to
there is
the-
I haven't come across any judgment.
It is-
But the problem is that an execution court passing an order thereby dropping the decree is a rarity. So therefore, the possibility of there being a judgment itself is low. My learned friend is able to produce, so be it. Lordship, I have one difficulty. A property was attached in the execution. At least let there be an undertaking, status quo will be maintained. We are on a question of law.
Question is this. Execution petition itself is not maintainable. It's a foreign judgment which sought to be executed ex parte. Court has taken exception in.
Oh, it is an ex parte judgment of the foreign court.
Yes.
That's very well explained in the judgment, saying the notice was issued, they don't come, a commissioner is appointed. Based on that, the court has applied its mind and passed the order. If they don't come and then say ex parte, that does not lie in their mouth.
The judgment of the Supreme Court is followed also, which I cited before the time.
At least let that property not be changing hands.
It's not.
It's a question of law to be decided on this. The judgment debtor transfers the property by way of a gift to the daughter. The daughter further transfers it by a gift to the grandfather. Grandfather is the objector before the commercial court. The manner in which the property has changed hands, grandfather gifting to the granddaughter, understandable. Granddaughter gifting to the grandfather to avoid the execution. Therefore, let that property at least remain in status quo till this question is decided. That's all that I'm saying. And I'm not saying attachment. At least let there be a bona fide undertaking that they will not further change hands.
We'll hear it on any near date. In the meanwhile,
Hear it this week, tomorrow, day after, any days,
Thursday,
Thursday.
Let the property not.
if there are any judgments, please see that.
Exactly, I'll share it with you.
But let there be an undertaking that property will not change hands, because that's the.
It's maintainable, even appeal is not.
So if there is a resistance to that lordship, then something more has to be seen.
Ever that be, unless we have, we are convinced that we are considered the appeal which is.
Lordship,
filed
we'll
is
come
not
back on
yet-
Thursday. We'll come back. I let you bow down.
Thursday.
We'll come back on.
(42). Singh Raju.
Some urgency in the matter.
What is the matter about?
Matter is about, there is an agreement between the petitioner and the appellant, responding, to start the film. Movie.
Awaiting respondent.
One and
notice
two,
to
Milord.
Respondent 1, 2, 3.
We tried to
and 5.
serve the copy to the council on record before the trial court. But she says, no, after get the confirmation of the company, I'll receive the copy. Maybe she on Saturday,
Notice has been taken.
notice has been taken, but she has not acknowledged.
Await, sir.
She has not acknowledged.
That is in addition. Have you taken out notice?
I have taken up the notice also,
Waiting.
but it may have it on Thursday or Friday.
And summons also.
And some also, they are not received. Even the Bombay, my lord, all the offices are situated. Now they are planning to release the film on 19th, my lord, 30th of this month. Moreover, my lord, I invested huge money. Huge money. For first, second, third schedule, I have invested the money. But immediately they have cancelled my term agreement saying that you have not paid the money fully in 4 schedule. They have accommodated other producers to start close the film. Now they are planning to release the film on 30th itself. Intentionally they have done it. I have on Thursday, my lord, I will try to serve the copy also.
Thursday.
Please.
43. Manmohan Priyan.
In maintainability.
The office objection is that, my lord, the impugned order is not passed by the commercial court, my lord. Inadvertently, you have filed this commercial appeal. May be permitted to convert this commercial appeal into miscellaneous first appeal.
Commercial appeal.
Miscellaneous first appeal.
ಅದೇ ನಾನು ಹೇಳ್ತಿರೋದು.
MFA is maintainable.
Please, my lord.
ಹೌದು ಅದೇ ನಾನು
Passed
ಹೇಳ್ತಿರೋದು.
on section 9 of arbitration. The appeal will lie under section 37(1) subclause B of Arbitration Act.
It is not by the commercial court.
Not by the commercial court.
Yes. Heard the learned counsel for the film. The memo is filed seeking conversion of the appeal. It is submitted that since the order appealed against is not one passed by the commercial court. It is a MFA which will be maintainable, miscellaneous first appeal which would be maintainable and not a commercial appeal. The overview of the matter, the memo is accepted on record. The prayer for conversion is allowed.
My lord, there is some urgency. May I seek for day after tomorrow, my lord?
Yes, this day after tomorrow.
Please, please.
Monday, sorry, I'm told that it will take some time for the conversion to Tuesday, 27. 27.
Please, my lord.
Passed on matter. Twenty-four. Chandranath Tariga.
May I seek for a passover, my lords?
Here at 4 o'clock also.
Seniors on his legs, my lords.
We'll have it on some other day. Yes.
Monday, my lords.
Monday. Monday
Is, sorry, Tuesday, my lords.
Monday is not working.
No, Tuesday, my lords.
Thirtieth.
30th. Wait for minutes.
Final hearing. 44 urgent, 45. H.N. Basuraju.
For the appellant, my lord. My lord. Contesting. Senior counsel engaged in quota 12. 1 week after.
Lordship, may I have it on 4th May.
4-9.
Once it was dismissed for default, it was dismissed, then it was restored.
Yes.
Lordship, may I call it on
46. 4-9.
4th, date.
45.
Records are received.
Records were called for.
Records are here.
Yes.
Please.
46. Prashant H.S.
For petitioner, my lord. Kindly please for 2 weeks' time, my lord. Senior has personal inconvenience.
Memo of retirement is accepted. Memo of retirement is accepted.
It has to be accepted.
No, it has to be accepted and the name of the council has to be shown.
Correspondent.
Yes.
$47. Radha Krishna Holla.
Of the appellant, my lord.
Yes.
I for the respondent. Disputes Act. Appellant, my lord, is engaged in the manufacture of the packaging materials for confectionery industries, my lord. And the respondent was appointed as vendor development engineer, which is a skilled and creative work he's supposed to do. He has to design the nature, the equipment with proper drawing and all. And his nature of duty is more creative and conceptual in nature. He is not a workman, my lord. That's the contention before the labor court. My contention was upheld, my lord. He said that he was not a workman. And accordingly, the termination as per the terms of appointment is held to be in order. That has been challenged by the workman, my lord, before the learned single judge. And learned single judge, my lord, referring to the two clauses in the appointment order and also the another nature of this, run by the fact run by him, held that he is a workman without inquiry. He has been dismissed from service and awarded full back wages, my lord, from the date of this one.
Therefore, the only question we have to consider is what was the nature of his engagement?
Yes.
What was the finding of the tribunal and what was the finding of the learned single judge?
Yes, my lord. My lord,
Yes.
now kindly see, my lord. The learned single judge's order is at page 14. I read
Yes.
from the para 6, my lord,
Yes.
page 18. Learned counsel for the petitioner further submitted that labor court has come to the erroneous conclusion that the petitioner had started a separate independent business and consequently the termination of the petitioner from service of the respondent management without holding any inquiry was just and proper. In this context, learned counsel invited my attention to the reasoning adopted by the labor court in order to contend that merely because the petitioner's wife was carrying on business under the name and style of BMP Rose Company, but the appellant, my lord, AMP Rose, similar company he has started. BMP Rose Company belonging to herself and her brother. The said circumstance cannot be made basis to come to the conclusion that it was a petitioner who was doing the said business, thereby entailing termination of his services by the respondent management without holding any inquiry, and consequently the finding of the labor court with regard to issue number 2 also deserves to be set aside. Per contra, the learned counsel for the respondent management submits that evidence of management witness and other material on record clearly establishes that the petitioner was not a workman within the meaning of section 2S of the ID Act. It is contended that labor court has come to the correct conclusion that the petitioner who is running the business in the name of his wife, and consequently respondent was fully justified in terminating the services of the petitioner. Learned counsel for the respondent also invited my attention to the reasoning and findings recorded by the labor court after referring to the decisions of this court as well as with the Honorable Supreme Court, and submits that the labor court has come to the correct conclusion that the petitioner was involved in performing duties of a conceptual and creative work and that he cannot be considered as a workman within the meaning of section 2S of the ID Act. It is therefore submitted that the impugned award passed by the labor court being just and proper, the same does not warrant any interference by this court in the present petition. The learned counsel for the respondent also submits that long and inordinate delay of more than 3 years on the part of the petitioner in filing the present petition against the impugned award is sufficient to indicate that there are bona fides in the petition and the same is liable to be dismissed. I have given my anxious consideration to the relevant submissions and peruse the material on record. Insofar as delay and laches on the part of the petitioner in filing the present petition is concerned, by way of amendment, the petitioner has inserted para number 3A to the memorandum of petition inter alia contending that delay of more than 3 years in filing the petition was on account of several domestic problems faced by the petitioner and handing over of the case to some other counsel who did not file the same in time, which required change of counsel, and also due to health issues of the petitioner was suffering from left eye defect for several months. It is relevant to state that though this court allowed the said amendment application by order dated 21/9/2015, permitting the petitioner to amend the petition and to explain the delay in filing the petition, respondent has not chosen to file additional statement of objections controverting the explanation offered by the petitioner in delay in filing the petition by way of para number 3A to the memorandum of petition. Under the circumstances, Accepting the reasons stated in para 3A of the amended writ petition, which has not been controverted or disputed by the respondent by filing any objections, I am of the considered opinion that delay on the part of the petitioner in filing the petition has been satisfactorily explained. It is, however, to be stated that petitioner would not be entitled to any relief for the delayed petition because delayed period because effective date of impugned award and date of filing the writ petition. Before advertising the material on record, it is relevant to state that the respondent management has complete control and custody of the entire records with regard to the nature of duties to be performed by the petitioner workman. In this context, it is relevant to state that clause 3 of the letter of appointment, respondent management has specifically stated that petitioner should perform all duties attached to the post to which petitioner was appointed as vendor development engineer. However, in the facts of the instant case, the respondent management has not produced any material to indicate the nature of work duties attached to the post of vendor development engineer, and consequently, adverse inference in this regard has to be drawn against the respondent management, particularly in the light of the impeached and uncontroverted testimony of the petitioner with regard to the nature of duties. Clause 15 and 16 of the letter of appointment reads as under. Well, these clauses, my lord, as the general clauses in the appointment order. Factual aspects has not been examined by the learned single judge, my lord. If necessary, I'll read, my lord, it's just 15 and 16, my lord. Yes, just clauses in the appointment order. For any reasons of shortage of power, breakdown of machinery, accumulation of stocks, or for any other reasons, there is no adequate work to be given to you. The management reserves the right to lay off, and in case establishment has employed less than 50 workers on an average on any day during the last 12 months, you will not be eligible to be paid any layoff compensation. However, in case of my establishment employs more than 50 workers, provisions of Industrial Disputes Act relating to layoff shall apply. However, if the establishment employs more than 50 workers and your layoff extends beyond 45 days in a total of 12 months, period of layoff above 45 days shall be without compensation. 16. You shall not strike work either singly or in concert with others without giving to the management notice at least 15 days in writing of your intention to strike work and before the expiry of the said period. The violation of this clause, apart from attracting disciplinary action, shall also make you liable for reduction of wages as provided under the section 9(2) of the Payment of Wages Act. The perusal of the aforesaid clauses in the letter of appointment is yet another circumstance which would give rise to a clear inference that petitioner is a workman within the meaning of section 2(s) of the ID Act. The aforesaid evidence of the petitioner, wherein he has not only submitted about the nature of his work, but also specifically stated that his work was a mixture of clerical, technical, and manual work, has not been impeached or controverted by the respondent management in the cross-examination. Further, except giving suggestions in this cross-examination, the credibility or veracity of the testimony of WW1 has not been impeached or shaken in the cross-examination, thereby leading to the sole inference that the petitioner was a workman within the meaning of section 2(s) of the ID Act. So also, as rightly contended by the learned counsel for the petitioner in his evidence as WW1 has specifically stated at paragraph number 4 as under. I say that during my employment, nature of my work was establish contacts with various vendors in Bangalore and get the engineering parts manufactured as per the drawings supplied by the customers. For the supply of packaging machines, these parts used to be assembled at a second party factory. Other engineering parts used to be brought to the second factory and dispatched to various customers in other countries. Like me, 2 more persons were employed to attend to outsource manufacture of engineering parts. My work involved use of my engineering skill. I was required to do calculations of costing of engineering parts, preparation of purchase orders to be placed on vendors, and follow-up work in the process of manufacture of engineering parts at vendors' place. My work as a mixture of clinical, technical, and manual work. It is also relevant to state that in the cross-examination of the respondent witness MW1, the said witness has admitted that it was account manager who receives orders from the customers and was entrusting the said works to first party petitioner for securing vendors. MW1 has also admitted that as per the instructions of accounts manager, the petitioner was approaching vendors and collecting all particulars and then preparing purchase orders and submitting the same to second party respondent. However, the very job of receiving orders was done by the accounts manager and not by the petitioner. MW1 has also admitted the director of the company approves the work order and forward the same to the accounts manager and then to the executive secretary and ultimately to the first party petitioner. And first party petitioner was doing only routine work as mentioned above. MW1 has further admitted that no other person was directly working under first party petitioner and he had no authority to sanction leave to any workman. MW1 has further admitted that first party petitioner was not supervising work of any workman in the respondent management. Further, at page 5, number 5 of his cross-examination, MW1 has admitted that the petitioner was preparing purchase orders as part of his duties, which was to prepare cost calculation of the job entrusted to the vendors. Under these circumstances, it is clear that the cumulative effect of the material on record discloses that while petitioner was not doing any supervisory work, his duties were merely clerical, routine, and managerial duties, thereby indicating that he was a workman within the meaning of Section 2S of the ID Act. In the facts and circumstances of the obtaining in the instant case, I am of the opinion that Labour Court committed a grave and serious error in coming to the conclusion that petitioner was not a workman and consequently said finding and evidence recorded by the Labour Court deserves to be set aside. So far as finding recorded by the Labour Court with regard to termination of the petitioner without holding any inquiry on the ground that he was carrying on a private business in the name, style and name of BMP Rose Company is concerned, as stated supra, the said company, which is in fact a proprietary concern of which the petitioner's wife is sole proprietor, coupled with the statement in the cross-examination MW1 that the said business was being done by the petitioner's wife along with the brothers, as well as the fact that respondent management have not produced any documentary evidence to show that business was carried by petitioner himself. I am of the opinion that finding of the Labour Court that the petitioner was carrying on a separate independent private business is based on surmises and conjectures and not based on material evidence, and accordingly said finding recorded with Labour Court also deserves to be set aside. I draw your attention, your lordship, to the relevant document, my lord, just produced before the Labour Court. Annexure L, page 91, your lordship may kindly see. That was exhibit M.
Just a moment, can we just go into 2S to see whether a person who's doing some kind of creative work as according to you,
Yes, ma'am.
will that take him out of the definition of workman?
Definitely, my lord. I rely on the Supreme Court decision, my lord, which was reported in the UP State Road Transportation. Some few paras I'll read, my lord. Whether inquiry is necessary, if the inquiry is not held, then the Labour Court is competent to examine that question.
No, the question is only this: if he's a workman, definitely the inquiry is necessary.
He's
So
not a workman, my lord. Kindly see.
that is the question.
Yes, my lord.
So what does 2S say?
It has to be, my lord, either clerical, manual, or technical.
Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled,
Yes.
technical, operational, clerical, or supervisory work for hire or reward.
Yes, ma'am.
Whether the term, therefore, just the fact that he's doing, there is some conceptual element in what he's doing will not take him out of the definition of workman.
No, that has been examined by the Labour Court, my lord. It's only but it's one case, Supreme Court is case.
Yes,
That award of the Labour Court is at page 98, Annexure M, my lord.
if he is in managerial or administrative capacity, he is not a worker.
Yes, my lord.
If he is employed in supervisory capacity, draws wages exceeding 10,000, etc., also he is not a worker.
True, my
But-
lord. No, this has been examined by the Labour Court, my lord. Kindly see reasoning of the Labour Court, my lord, in the award.
Hmm.
103, page number.
Hmm.
Issue number 1.
Hmm.
First party has contended that he joined the services.
Hmm.
Just read me, 103. First party has contended that he joined the service of the second party management as an engineer on 1/7/1988, and that his services were terminated on 4/9/2003. He has also stated that he was drawing a monthly salary of 15,830. Second party management has specifically contended that first party is not a workman within the meaning of Section 2S of the Industrial Disputes Act 1947, and therefore this proceeding is not maintainable in law. It is a specific contention of the second party management that first party was appointed as vendor development engineer to discharge the managerial functions in purchasing the requirements of the second party management, and his duties were to identify new purchasers and evolve new purchase procedures to the best advantage of the second party management. It is also stated that The past experience of the first party in the said field of supervision and management was taken into consideration for his appointment. Therefore, second party management has contended that the first party is not entitled to raise an industrial dispute. In fact, burden of proving the status of the first party as a workman ought to have been cast on him, but it has been cast on the second party management. However, both the parties have understood the point of objection raised in the second party management in this regard, and they have led oral and documentary evidence. First party got examined himself as WW1 and has stated that he was appointed as vendor development engineer on a monthly salary of rupees 10,000. As per the appointment letter dated 23/6/1998, he is a holder of diploma in mechanical engineering. According to him, his last drawn salary was 15,830 per month. In para 4 of the affidavit evidence, he has stated that during his employment, nature of work was to establish contacts with various vendors in Bangalore and get an engineering parts manufactured as per the drawings supplied by the customers. He has further stated that for supply of packing machines, these parts used to be assembled in the factory of the second party. Other engineering parts used to be brought to the second party factory and dispatched to various customers in other countries. 2 more persons were employed to attend to outsourced manufacture of engineering parts. His work was involved in use of engineering skill. He was required to do calculation of costing of engineering parts, preparation of purchase orders, and to follow up work in the process of manufacture of engineering parts at vendor's place. Lastly, he has stated that his work was a mixture of clerical, technical, and manual work. During the cross-examination, first party has stated that he was working as an engineer in the machine shop, but he has denied the suggestion that he was working as a manager under second party management. However, he admits that he was doing some technical work. Thus, the effort of the second party management is to point out that he was not working as a clerk or any manual worker. He admits that he was appointed as a vendor development engineer by letter dated 23/6/1998 as per Exhibit W1. The learned counsel appearing for the first party has submitted that as per appointment letter of the confirmation, first party was entitled to leave according to Factories Act and rules made thereunder, and his service conditions would be governed by the standing orders, service rules and regulations of the company. Therefore, according to him, first party falls within the category of workman. He further submitted that first party was entitled to other benefits under the Payment of Wages Act. Therefore, he cannot be supervisor or manager under the second party management. The learned counsel appearing for the second party management has contended that merely because certain provisions of industrial laws are made applicable to a person by virtue of any contract entered into between them, then it cannot be said that such person is treated as workman. Therefore, he further argued that such person cannot be a workman under Section 2S of Industrial Disputes Act 1947. In support of his contention, he has relied upon the decision reported in 2005-1 ALJ 364 in the case of Vishakantaya TN versus Management of Mysore Petrochemicals Limited, Raichur and another, wherein the Honorable High Court of Karnataka was pleased to hold that primary and substantial duty performed by the person is irrelevant to determine whether he is a workman under Section 2S of the Industrial Disputes Act 1947. In para 11 of the said judgment, the guiding principles which the court should bear in mind have been laid down as under, though the court shall adopt a pragmatic and not a pedantic approach. What the court has to see is what is the primary and substantial duty which the person is performing. Is the said work managerial, administrative, supervisory nature? What is the remuneration paid for? Then to consider which side of the line they fall, labor or management, and then to consider whether there are any good reason for moving them over from one side to other. In arriving at conclusion of the nomenclature attached to the designation should not blur the mind of the court. Similarly, some additional or incidental duties attached to the main work should not be given undue weightage. The substantial duty performed by the person could be gathered from the terms of the order of appointment, terms of contract if entered into, also from oral evidence and such other materials the court comes fit to rely upon. Any one of them is not conclusive. It is a question of fact. Therefore, it is a cumulative effect of all the materials placed in record should be made basis for the finding whether he is a workman or not under the Act. Lastly, the learned counsel appearing for the second party management has relied upon the decision reported in 2005-1 LLJ 1122 SC in the case of management of Sonipat Cooperative Sugar Mills Limited versus Ajit Singh, wherein it is also a question of determination of status of workman was considered, and it was held that if a person employed in any industry and performs any manual, unskilled, skilled, technical, operational, clerical, or supervisory work, then he falls within the category of a workman as defined under Section 2S of the Industrial Disputes Act 1947. But according to the learned counsel appearing for the second party management, the first party is not doing any above mentioned duties, but he has been performing duties which he himself has mentioned in para 4 of his affidavit evidence. But the learned counsel appearing for the first party has relied upon decision reported in 1975 to LLJ 189 in the case of Marshal Braganza versus S.R. Samant, presiding officer, the first labor court, another, wherein it has held that a film cameraman is a workman. But considering the principles laid down in 3 rulings relied upon by the learned counsel appearing for the second party management and the evidence that has been produced by them through MW1, it is very much clear that second party management was neither appointed as a workman nor he was discharging duty as a workman as defined under Section 2S of the Industrial Disputes Act 1947, but he was appointed as a vendor development engineer and he was discharging duties independently, and that he was taking a decision independently by identifying new purchasers and by evolving new purchase machineries to the best advantage of the second party management. His duty involved creative work and on the basis of his past experience in the field of purchasing. Therefore, his duty was not that of supervisory nature, but is a capacity of manager. Therefore, he cannot fall within the category of clerk or manual worker. Therefore, merely because he was not sanctioning leave or to any person, as stated by him in cross-examination, he cannot be excluded from the category of a manager. In fact, in cross-examination MW1, it has been elaborately suggested by the learned counsel appearing for the first party itself to go to show that the nature of duty performed by the first party is that of an independent vendor development engineer and not that of any clerk or manual worker.
Just a moment, counsel. Can we interrupt you for a moment there?
Yes, ma'am.
The labor court appears to have gone on a tangent. Does not have to be manual work at all. Skilled work is also work to come within the definition of 2S, which is why we asked you to read 2S in the first place. 2S does not say that it has to be manual work or clerical work. Skilled work is also, only because it is what is being used is some kind of creative energy, that does not take him away from the,
Hello.
you have to specifically aver that it is either managerial, administrative or supervisory.
Hello. Sonipur Sugar Mills case, Supreme Court says that in order to be a workman, you should be come under one of the 7 categories.
Exactly.
Manual.
Skilled worker. Skilled worker is yes, it is.
I mean, nature of duty is creative work, my lord. And of course,
the labor court in this case
yes,
appears to have gone on the presumption that to be a workman, a person must do some kind of manual work or clerical work. Not true. It is not so. That is not the definition of workman under 2S.
my lord, just I'll take your lordship. The doctrine, the issue was commented on by the single, the page 91, annexure L, my lord, is the, I mean, the registration, it's a certificate of this one, wherein it is stated that name of the applicant Mahadevi, is the wife of the, I mean, the workman. She was provided.
That is another question altogether. There, if that is your contention,
yes,
then you ought to have issued a notice and conducted an inquiry, found him to be unfit to hold the office. It could have been done.
My lord, this
Termination could have been done with proper notice. Nothing.
This way, Supreme Court says, my lord, I mean, the inquiry is not necessary.
Inquiry is not necessary.
Some evidence is there before labor court. Just 3 points I will.
Yes.
When you see para 5, my lord.
Yes.
5 there, and then the next page, my lord. 3, clause 3. When the proper inquiry has held by the employer and finding his misconduct is possible conclusion flowing from the evidence adduced at the inquiry, the tribunal has no jurisdiction to sit in. The inference with the decision that employer will be justified only when the findings arrived at inquiry are corpus or the management is guilty of victimization, file labor practice or malpractice. Next, my lord. Or if the inquiry is held by him is found to be defective, the tribunal, in order to satisfy itself about the legality and validity of the order, had to give an opportunity to the employer and employee to adduce evidence before it. It is open to the employer to adduce evidence for the first time justifying his action, and it's open to the employee to adduce evidence contra. This has been done by the labor court. Next one, my lord. The effect of an employer not holding an inquiry is that the tribunal would not have considered only whether there was a prima facie case. On the other hand, the issue about the merits of the impugned order of the dismissal or discharge is at large before the tribunal, and the latter, on the evidence adduced before it, has.
Where is the evidence adduced before the tribunal?
Pardon me?
Where is the evidence adduced before the tribunal with regard to the
Yes,
allegation
ma'am.
as against the petitioner, as against the employee?
Yes, my lord, that is the award itself, it is there, my lord. No, I'll take your lordship. Exhibit affidavit evidence of the workman. Page 70, my lord, annexure J. It's a Basura Medal son of so he's a workman. I am the first party workman in the above dispute. And as such, I am conversant with the facts of the case I am reposing to.
That is just his deposition.
Yes.
It is not the question. When there is no inquiry conducted.
Yes, ma'am.
By the management.
Yes, ma'am.
And you're contending that it is on certain proven facts, that then he has to be put on notice before the tribunal, and his evidence has to be taken by the tribunal. Where is it done?
This evidence, will affidavit evidence, it has been taken.
That is with regard to his claim. As the claimant there is, it is with, where is the evidence taken on the charges as leveled against him by you?
No, my submission.
That is the import of this judgment.
Well, my submission is that, my lord, if the contention is that he is not a workman, the service was terminated.
Correct. If the contention that he is not a workman is accepted, then the other question is, then the tribunal, I mean, the labor court or the tribunal cannot go into the other question at all.
Yes, ma'am.
It is completely devoid of power. It is only if he is a workman that this issue can be considered by the tribunal. Otherwise, the tribunal is a stranger. Therefore, after having said that he is not a workman, then saying that his wife has started.
Well, that is the reason for terminating service, my lord.
No, that cannot be. If he is not a workman, it ends there. If he is a workman, then the other question has to be considered whether his termination without a proper inquiry is proper or not. If he is a workman, and if there is a termination without an inquiry, then the labor court has to consider it as sitting in the shoes of the.
On the material placed before labor court, let us come to the conclusion that he is not a workman.
Yes, that we'll understand. That we understand. But the learned single judge appears to have come to the conclusion that that finding is flawed.
My lord.
In as much as there is no finding that he is exempted from the definition of workman.
My lord, then I'll come to the ground of delay, my lord. Award was passed on 17/3/2009, my lord. Writ petition was filed on 5/10/2012. After 3.5 years. The application for condonation of delay has been filed on 9/9/2005, effectively after 6 years from the date of loss of action. My lord, kindly see the application, my lord, delay. He has stated a bald grounds, my lord. Last week, kindly see the IA number filed on 9/9/2015. It says, my lord, for the reasons stated in the accompanying affidavit, the petitioner prays that this honorable court be pleased to permit the petitioner to amend the writ petition for condonation of delay in filing the writ petition in the interest of justice. Schedule of amendment. The petitioner has filed this writ petition nearly after 3 years due to unavoidable circumstances like several domestic problems. The petitioner has handed over the case to some other advocate, but unfortunately, he did not file the same in time, and as such, I changed the advocate and filed this writ petition, and hence there was a delay of 3 years from the date of publication of award of the labor court and suffering from left eye defect over several months, and as such, petitioner prays to condone the delay in filing writ petition as there was bona fide reason. The number of days of delay is also not mentioned, my lord. No proper justification for the delay.
Yes. What do you say?
My lord, there was a delay of 3 years in filing the writ petition, for which the single judge has waived off that benefit for the period of 3 years. Though the application of delay has been condoned.
The appeal is on both grounds. Appeal is on all grounds.
Yes, my lord. Yes, my lord.
Including on the ground of delay.
My lord, with regarding section 2(s) of Labor Act, my lord, wherein the cross-examination of the management can be seen, wherein the management witness, he says that no one was working under him, and he was supposed to act upon the instruction of the manager. That is what the management has admitted in the cross-examination. That has been completely never looked by the labor code, which learned single judge of this court has seen, and it has been appreciated. And my lord, non-conducting of the inquiry, my lord, domestic inquiry, which is against the principle of natural justice, though he has replayed that he is innocent and he has never committed such offense alleged. When he through his reply, the inquiry has not been conducted. Inquiry has not been conducted. It means that it is against the principle of natural justice, and I have been deprived of my rights of defending myself. And straight away jumping into conclusion that he is guilty, my lord, that will not survive. And moreover, my trial, kindly it can be seen the trial court, the labor court's issues, my lord, in page number 100 and
Yes.
in page number 107, 107, my lord, 102, sorry, my 102, wherein whether the second party proves that the first party is not a workman as defined under section 2S of the Industrial Disputes Act. Second issue was whether the second party is justified in terminating the service of the first party, and what relief and first party is entitled to. Wherein the same page, my lord, the labor court held that the termination was proper, affirmative. My lord, that itself is against the principle of natural justice, my lord. And moreover, my lord, though the reported judgment which is quoted by the labor court, which is in our favor, but the court has misconstrued it in such a way that court has held that he never comes under the Workman Act, and he is entitled for the any relief as prayed, my lord. My lord, which itself shows that, my lord, my lord, the management being in authority to produce n number of documents with regarding the nature of duties of the employee, wherein the management has never produced a single piece of paper to show that he was in a managerial post or he was in a superior post, to show that. In fact, my lord, in the contrary, my lord, the employee who has come on behalf of the management, he clearly says, my lord, he was not working, and he was only working under manager instruction, and no one was working under him, and he has no authority to grant any leave, or he has no authority to direct any work to anyone. He was supposed to work under the instruction of his manager. That is a clear evidence, my lord, even in the appointment letter, my lord, wherein in appointment letter can be seen in annexure B, my lord, in page number 40. This is appointment letter, my lord, wherein the last clause in 42, my lord. However, in the second 15th para, my lord, in between, however, in case establishment employee more than 50 worker proves that industrial issues are relating to layoffs, so and so, my lord. And my lord, in the last line, action shall also make liable to deduction of wages provided under section 2 of the Payment of Wages Act. It also shows that, my lord, all the labor's rules have been framed in his appointment letter, my lord. And even in the even in all the records, my lord, nowhere it has been shown that he was supposed to work as a manager or a supervisory, my lord. When in the absence of all this thing, my lord, when the management was supposed to produce a number of documents to establish that he is not a workman, he was at any point of time he was directed any employee, or he was in authority position to deliver any work to anyone. But in the absence of it, when management was very negligent in straight away terminating him, and even, my lord, not even producing the single document, that itself, my lord.
What was your date of superannuation?
No, he's already superannuated.
Yes.
At the time of passing the order.
By the time the order was passed, you had already superannuated.
Yes, my lord.
No, here it says 61 years on 2022.
Be entitled to all consequential benefits, excluding the period from the date of impugned award becoming effective during this petition. No benefits have been granted during the period of delay.
Yes, my lord.
Can we take it for judgment? Reserved for judgment.
Much so.
There is an interim undertaking by the respondent that may be extended, given that today there will not be time. Item 50, Lord.
50, 50.
50. And may I request for a date, Lord?
It is an interim undertaking. The other respondent is not here. What is the undertaking?
That they will not precipitate execution.
The next matter, my lord, serial number 48. It was a case of dismissal of 1986, my lord, between me and my learned friend.
86 dismissal.
86 dismissal. It's a,
Give
Award
a-
was passed in 2010, my lord.
Sorry?
Award was passed in 2010.
no, it's got some history, my lord.
Yes, we'll have this on a near date. Please give a date. Can we list this in some other list?
Yes,
So
ma'am.
that there is a chance that it can be taken up,
That's true, my lord.
because in final hearing, it does not appear to be reaching.
I may not take more than 10 minutes, my lord.
If you can prepare, both of you can prepare a short synopsis, we can list it in some other list and try to get it over.
Yes.
Give a date. Please. Please agree on a date, can be given. Yes, 50, the,
50 also. Can I request first week of September, sometime in first week?
yes.
Great.